My lord, may I be permitted to mention one urgent? 217 of the combined list. The compensation has not been given to me. My shop room has already been demolished without acquisition of my land. Therefore, my letter.
My lord, on extreme urgency, my lord, may I seek my lord's leave to file this matter on urgent basis to move the matter tomorrow top. As I say, my lord,
What is your urgency?
urgency is, my lord, without any acquisition process in the middle of the plot, my lord, a pump set is being installed by the irrigation department. My entire plot will be, my lord,
File and give the number. I'll take
my
it.
lord,
And there's
my
no urgency for leave.
my lord, the difficulty is, my lord, if the pump set is installed, my lord, the entire plot I will not position to utilize, my lord. They can, without any acquisition process, nothing is there, my lord. Only, my lord, this is the urgency, my lord. Kindly grant me some leave, my lord, so
It's
that
for a public purpose. Leave is not
my
necessary.
lord, there is no acquisition, my lord. Public or maybe, but they can install the pump in side corner or anywhere. But it is my plot, my lord. It is my
He
plot.
will file and come back. Give
My
the
lord,
number.
kindly-
I know. No, leave
My
will
lord,
not be
kindly
granted.
give some paper so
No,
that
no,
I can move the
Give the
matter.
number. File and give the number.
Tomorrow, my lord, at
Yes.
top, my lord, I will.
File and give the number. I'll see.
My lord, I have a very unusual request to make before the lordship, my lord. My lord, all the petitioners are 75 years old. My lordship, earlier occasion was gracious enough, my lord, to fix the matter also in the supplementary list. Now, my lord, all are above 75. I am supposed to get, my lord, admittedly 7.5 crore from the government. Shoptangshu Bose is leading me in this matter. If the matter can be any day at 3:30, my lord, hearing matter, any day at
It's not
3:30.
possible. It's in the supplementary list.
Yes, now it's in the supplementary list. Now, if lordships kindly, my lord,
3:30 will
because
not be
all are
possible.
seven.
I have several 3:30 matters
why-
already running. I cannot add another to it. So come back.
Well,
Let's see.
what I am saying, my lord, in next month, one date, 3:30. I am not saying that tomorrow, my lord, any day convenient to your
Why
lordship.
don't you mention next month? Let me see.
Look.
There are several 3:30 matters actually. So I cannot fix matters like
My lord,
this.
if any precedence can be
There
given,
are
my lord.
partnered matters which are.
I understand, my
There
lord,
are
I understand. But all petitioners are 75.
Mention in the next month, in the first week. Let me see.
Lordship, lordship. I will remind your lordship, my lord. I am
Lordship, may I permitted to?
Madam, may I mention, madam, for correction of the order dated 13th of
Give the
September.
number, give the number, please.
Correction, madam, I have marked.
Lordship, may I permitted to mention one matter? Lordship, is the second round of litigation. In the first state petition, your lordship directed the estate manager Kolani to consider the petitioner's representation regarding granting mutation, but the your lordship's order was not properly complied with. That is why application for contempt was filed. After serving the contempt application, the respondent authority rejected the prayer of the petitioners. This is why this second round of writ petition has been filed. Yes, lordship, item 636.
Give the number.
My lord, I am mentioning these matters upon notice to the other sides. Yesterday, these matters were listed as at number 2, 3, and 4. But since we have missed the bust, so and your lordship has been pleased to fix this matter sometimes in the month of November.
Yes.
Okay, it's all right. Let that be fixed. But some formalities are required to be done before the final hearing.
What
takes place.
formalities are required?
Some papers to be exchanged, some papers to be submitted.
Do that on the next date. There is no
And let
urgency.
it come under the to be mentioned tomorrow.
You want to submit the documents, isn't it? You can do that on the next date. Serve advance copies to the others so that they are ready.
We have already served advance
Yes,
copies.
so if you submit on the next date, there is no difficulty.
Then the next date will go in vain.
No, why? You have served the others.
Yeah, I have served the
Others
others.
are ready. The court doesn't see the documents earlier.
Lordship.
So file the documents on the date fixed.
So it is in sometimes in the November. So it can be.
Yes. So when the date comes, file your documents on that date. Yes,
Okay,
next.
Your lordship,
I'll-
new motion for upgradation. The private respondents as authority undertake unauthorized
Give the
constitution. My lord, matter relating to fake stamp paper, my lord.
Give the number.
My lord, another is subscription application.
Kunta. Fake stamp paper. The new motion এমনি আসবে। Yes, call the raised list, please.
One.
And I am appealing for the petition, the respondent. State of the.
Petitioner,
Yes, madam.
For the state, my lord.
लिखे नहीं जो कुछ लोग लिखे नहीं क्योंकि
the writ petition has been dismissed. I'll read out the relevant portion, the operative portion. The conduct of the board is a glaring example of misuse of power and unauthorized purposes being pursued without demonstrating any grounds supporting the validity of its conduct, such act being eventually admitted by the board. In the said backdrop, this court is inclined to hold that since the development agreement emerged from the deed of lease, which has been cancelled by the department, the agreement cannot stand on its own. The illegalities and irregularities evident in the agreement as admitted by the board could not have been allowed to continue, for which the department was constrained to take the decision of termination of the lease, which formed the basis of the agreement. The lease having been granted for a specific performance could not have been used for the purpose of patronizing the private company by entering into a development agreement in contravention of the lease deed. Therefore, the writ petition is dismissed.
madam, may I pray for stay of operation of the order?
Considered and rejected.
Grateful, madam.
Then order করতে হবে stay petition. Later করে separate sheet করবেন। Same sheet. Learned counsel for the petitioner. Petitioner seeks a praise for a stay of the judgment. Paragraph. The prayer is considered and rejected. Chamber. Yes, next. Better, but. Item 2.
Well, at item
Yes.
number 2, 3, and 4 are the similar matter, my lord. Can it be taken up any other day, my lord? My lord,
I'm for the respondents.
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on, what is the application about?
my lord, this is very short matter, my lord, fully covered by the order of this court, my lord. My lord, there is a provision for construction of a private siding. There is a 3 type of private siding where railway provide land, where my lord investor have own land, and where investor also having land and railway land. Here, my lord, a portion of land, 2.37 acre land in item number, my lord, 2, my lord, that land has been provided by the railway to the petitioner, my lord. Now, my lord, in principle approval was given at a time when circular number 41, that is, my lord, dated 31st March 2005 is applicable. But when railway raised bill for, my lord, land licensing, my lord, they raised bill in view of a circular 2008. My lord, this is, my lord, under challenge in this 3 writ petition.
Yes.
Subsequently, my lord, another writ petition, my lord, going to finality, my lord, where this honorable court was pleased to, my lord, pass an order where court specifically, my lord, mentioned that no, the circular which is applicable, which is my lord, that point of time when in principle approval was
That
given,
will be
that will applicable to us. So my lord, I am fully covered by that, my lord, order.
What does your application say?
My
That's
lord,
the writ
I
petition.
file an application asking for, my lord, disposal of this 3 writ petition, my lord, in view of the order passed earlier. And my lord, the subsequent
The
step.
applications can be taken up along with the writ petitions, I think. No separate
Yes.
hearing is necessary.
No, my lord, no, my lord.
So let the matters appear under the heading motion
My lord, if
along with the applications.
there is already, my lord, affidavit has been exchanged.
Oh, this is a hearing matter.
Yes, my
My
lord.
lord,
So if your
particularly,
lordship, this is a very short matter. If your
Because
lordship
your
hear the
application
application.
asks for disposal of the matters
Yes, my lord.
in terms of the earlier orders. So the
Yes.
applications can be disposed of along with the writ petitions. That
We-
is what I understand.
We bring all
lord.
documents, my lord, in my application. Documents means, my lord, the order and subsequent communication
application-
between me and the
Petitions
railway.
themselves can be considered along with the applications,
Yes, my lord.
because separate consideration of the applications will not really help.
Yes, yes, my lord. Yes.
Because your prayer is for consideration of those documents.
But if
Yes,
your
Mr.
lordship
Ghosh?
fix this matter in a hearing, my lord, then we will not
Because
verbally.
in an application,
My
I
lord,
don't think anything further can be allowed.
my lord, in the application which is there,
Writ
that
petition
is not in the,
under the heading application, isn't it?
that is not in the main writ petition. And my lord, kindly come to the page 63, my lord, of the
first
application, my lord.
Application at page 63. Application.
My lord, that application, that,
The application গুলো file নেই? I do not find your account. একটা application দিন না, একই। যে কোনো একটা দিন না। এইটাতে নেই কোনো application, if I give you a minute.
Page 63 of what?
can,
Order?
no, application to application.
থাক, থাক,
No, if it's, sorry, affidavit, no, affidavit, no. Sorry, my lord, the page 63 of my affidavit in opposition, my lord.
To the application or to the writ petition?
Writ petition, in application, my lord, there was no such direction for filing of the affidavit in opposition.
Do you want to come back with affidavits in the application?
So, my lord,
also?
in that case, my lord,
So in that case, without wasting further.
I have
In
to fi- I have-
application, we just annexed, my lord, previous order passed by this honorable court.
my lord,
in a
kindly come to the
WPA
page
822.
63 of my affidavit in opposition, my lord.
I'm not on merits actually. Your affidavit
Yes,
in
ma'am.
opposition also I do not find. Did the affidavit in opposition? I just want to see the prayer of the application.
Yes,
Can
ma'am.
it be dealt with along with
It's-
the writ petition?
But just for one thing, my lord, for this decision, my lord, why I am praying to file the affidavit in opposition in respect of can, my lord, application, my lord. Page 63, my lord, that is a railway board circular which starts from page 61, my lord.
My lord,
That is the freight marketing circular 12 of 2008. For a moment, my lord, kindly come to the page 61 first, my lord.
I'm not getting your opposition.
Affidavit in opposition, my lord.
WP number to কত?
WP number 29101 of 2014. 4 নম্বরটা মনে হচ্ছে।
101.
হুম।
29101 এখানে দেখুন। Opposition কোথায়? Affidavits are complete in this matter
In my lord, main writ petition.
because the prayer.
One is already disposed of.
Kindly see the prayer, my lord.
I've
May I?
seen the prayers.
Yes.
This has to be dealt with along with the writ petition.
Yes, my lord.
Yes,
Application can be heard with the main writ.
Let there be a, because
Yes,
writ
that
petition has
in-
not been fixed for hearing, isn't it? Let the writ petitions be fixed for hearing along with the applications.
in my, and
I'll
my
deal
lord,
with all of them together.
yes, my lord.
Yes, my.
In that
But
case, my
can
lord,
we fix a
kindly give me an
can
opportunity to
reach-
file affidavit in opposition in respect of the application, my lord.
That's it.
Actually, my lord, what is stated in the writ petition and the
Because
connected
affidavit in
application,
opposition is not in the file. In none of the files, in fact.
My lord, may I file my reply in my lord item number 4.
In 2 and 3,
In 2 and 3, my lord, 3, item number 3, this matter has already been disposed of. But my lord, why your lordship tag this matter? Because my lord, we will rely some documents from item number 3.
Opposition has not been filed at all in the writ petitions. In none of the writ petitions.
Item number 2 তে তো opposition file হয়নি?
Actually, my lord,
item-
what happened, my lord?
No opposition has been filed till date.
My lord, I am appearing in respect of WP number 29101.
The writ petitions, your affidavit has been filed.
So in that case, my lord, leave may be granted to reaffirm this opposition, my lord. Affidavit in opposition. Actually, it was served. Reply was also filed. Anyhow, my lord, it is a change brief, long pending matter, my lord. Since
Find out whether you have the copy. If it is not,
yes, my lord, I have only one copy.
no, the original, the original.
No, my lord, original is not with us, my lord. We are on the impression that that was filed.
In all the 3 writ petitions, you have to file affidavit.
No opposition
No,
was
my lord,
filed.
in item number 2, there is no opposition. Right?
It's
But
not
in item-
no, there is no opposition in any of the matters.
Opposition.
So you need to file it.
তার মানে
Four,
file
isn't
হয়নি।
it? Three is
That-
For
disposed
this
of
is
matter.
my lord, so
This one.
Three
I
is
think my
disposed of matter.
3 disposed of matter, but this is
Four
very
need to
important.
file affidavit in
so my lord,
opposition.
kindly give me an opportunity to file the affidavit in opposition, which
In
is
the
not
writ
already
petition as
affirmed.
well as in the application.
Application, my lord. And which is already, my lord, opposition is filed. In that case, my lord, kindly leave me granted to file, to reaffirm this opposition, my lord.
Opposition is not filed, so you have to say that it is lost or something has happened.
Yes, my lord, original is lost, but I have a one copy in respect of 29101.
The other one, the second matter,
I mean, in the second
number
item,
2.
probably someone else is appearing.
তুমি কি দুটো
তুমি appear করছো না তো item
দুই
number
দুই আর চারে, দুই আর চার নাকি?
opposition.
And my lord, 3 is already disposed of,
2
2
and
and 4, my lord.
you are appearing in both the matters.
Yes, my lord.
তুমি কোনটায় appear করছো?
Application
4?
heading এ আছে।
2 and 4 ও দুটোতেই
Learned counsel for the respondents
ওর নামটা
seeks
কি?
to use affidavit in opposition in the applications
দিয়ে দিয়েছে নাম।
as well as the writ petitions.
হ্যাঁ, নাম দিয়ে দিয়েছে। দিয়ে দাও,
In
দিয়ে
the
দাও,
applications will stop.
Let this
Learned counsel seeks liberty to reaffirm the affidavit in opposition in WP number 13870 of 20.
29
Only-
29101.
And what about the other matter?
That was not, probably that was not filed, that was not at all affirmed, my lord.
You
So in
see,
respect
fine.
of item number
Item
2,
number 2, my lord, they did not file any opposition. In item number 4,
In the
there is a question of
application statement
reaffirmation.
and WPA 13870 of 2018. 870 of 2018. Stop. Learned counsel seeks liberty to reaffirm the affidavit in opposition in 29101 of 2014. This is a land matter.
My lord, this.
Group 1 or
Yes,
group
my
7?
lord, this is group 1.
group 1 matter.
So in that
Group
case, this 2014 matter cannot be taken up by this court unless it is
Group
it's
1
assigned.
দেখো না?
This
Group
court takes
group
up
1 matter, land related matter,
this
all
court takes up matters from 2017.
No, my lord. আচ্ছা, মনে হয় group 1 নয়।
land matter.
2014. Group 1. This is
I-
group 1, my lord.
So I cannot
Yes,
take
my
up
lord.
this matter.
Hmm.
The fourth,
It is 2014
you
matter.
can get it reassigned or I can release the other matter also to be placed before some other bench. I have to release it. I should have noticed it earlier. 2014 matter I cannot take up.
Understand.
My lord, it is a joint prayer, my lord. Let the, my lord, direction of
This
affidavit may be,
direction
my
may
lord,
be
given,
passed, my lord.
and we,
I cannot. The chief is the master of roster, so I cannot do this. Even on consent, I cannot.
yes, yes.
So in that case, any matter under any determination, the parties give consent and I think that
আরেকটা
would
কত?
not possible.
2
That's not
নম্বরটা
possible.
কত নম্বর আইটেম? 13870? ওটা কত? কোন ইয়ার কত?
ওইখানে stop করো।
জয়সেন রিলিজ করেছিল দিদি
ওই
জয়সেন রিলিজ করেছিল
হ্যাঁ?
My lord, item 2 is 2018 matter, my lord.
Yes,
Item number,
Item number 2 is 2018.
2 I can take up, 4 I cannot. I have to
Yes,
release
ma'am.
it.
Then, my lord,
You have to
kindly
get it
keep
aside.
item number 2 with your lordship.
I will.
2 and 3, my lord. 3
three is already disposed of.
3 is disposed of,
Written
but
as it is, as
yes.
they are.
yes,
4 I'm releasing.
yes,
If you want it to be heard simultaneously or analogously,
Yes.
you have to get it assigned.
yes.
And let me, in for that matter, let me keep it after vacation so that you take necessary steps in the meantime.
Yes.
You have to either take this matter away by way of assignment or bring the other matter.
Yes, madam.
Or if you want an individual disposal of only item number 2,
Madam, we
that
will
can be done.
place a letter for assignment, my lord, tomorrow and probably.
Come back next month.
Yes, madam.
Yeah.
Yes, yes,
You
madam.
want it before the vacation,
Yes.
decide.
We will try our luck, my lord, before
Very, very.
vacation, my lord.
Paragraph since no, একটা paragraph করে করুন WPA 29101 of 2014 is released due to lack of determination. 2014 along with the connected application thereto is released due to lack of determination. Paragraph, let the matters appear under the
In the meeting,
hearing.
but my lord, in item number 2, they did not file in opposition. So, my lord, last chance may be given in the meantime to file their opposition, if any they want to file. Otherwise, on the next day, they
Yes.
will again ask for time.
Hearing along with the applications on
দুইয়েতে application আছে তো? Item
না,
number
বাবা।
11th October should be sufficient, Mr. Ghosh.
Yes, my lord.
11th October.
My lord, kindly allow me to file the affidavit in opposition in respect of
I have recorded
application
that.
and
And
as well as the
petition.
writ petition also.
I have
In
recorded that.
respect of item
Yes.
number 2.
Applications and, yes, yes,
Yes,
I have recorded.
grateful.
And please serve advance copy so that she's ready on the.
Yes, yes. After vacation, my lord.
No, 11th October, I
Madam,
said.
11th October, man. Yes.
Please exchange your affidavits in
Yes,
the
madam.
meantime.
Yes, madam.
Yes, next.
Grateful.
Grateful, man. Porter released. We একটা লাইন অ্যাড করে দিই এটা একটা
Item 5.
Lordship, I am for the petition, Lordship. It's a restoration application, Lordship. We have filed the restoration application. Lordship, I will serve in the meantime, Lordship. Let the matter be restored, Lordship.
If
And
you allowed, then you'll serve.
absolutely. No, Lordship. The service is not
That is what
complete,
you're
Lordship.
saying.
But the state respondent is here, Lordship.
You're appearing for the state?
Statement.
It's a restoration application. Please serve him a copy here and
Yes,
now.
sir.
Third learned counsels for the parties. This is an application for paragraph. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 23rd February 2023. Paragraph, sufficient grounds being made out, the application is allowed, comma, the application is allowed. Paragraph, the order passed on 23rd February 2023 is set aside. Paragraph, the writ petition is respect to its original file and number. Paragraph, can such and such is disposed of. What about the writ petition? Can we deal with it now? Are you ready with the writ petition?
Lordship, 1 week's time, Lord, may be given, Lordship.
After vacation.
After.
WPA, let the matter appear under the same, under the heading motion on 22nd November.
Yes.
Application.
আপনার নাম্বার থাকে
Restoration. Can 1 and can 2. What is the other application?
That another is, Lordship, section 5 for the condonation of delay for filing the
Did
restoration.
you submit your submission, sir?
No, Lordship. If your Lordship asks.
Make a complete submission when you are
Yes,
before
your
a
Lordship,
court.
that one can application is for the restoration and another is for the
লাগবে না।
delay.
Section 5 টা বলবে, তারপর dismiss করবে। আচ্ছা, ওটার আগে করবেন। Section 5 টা আগে করবেন। Good grounds being shown. The
Delay of
in filing
159
the-
days, Lordship.
Yes,
159 days of delay, Lordship. 159.
good grounds being shown. The delay in filing the restoration application is condoned. Can such and such is disposed of. প্রথমটা। তারপরে
Grateful.
next,
22 অক্টোবর তাই তো জানতো
22 নভেম্বর 22 অক্টোবর 70 বা 80 হবে
আইটেম 6 বলা যায় না
হ্যাঁ
সেদিন কাজ করছে
I am the petitioner.
contempt, European, yes.
22 নভেম্বর তাই তো কাজে দেখাশোনা তো
Oh, this is that Borga land in between.
yes malad kindly plus this sketch map has been prepared malad the yellow color is the malad the land of the petitioner.
Yes,
Here malad the 3 plots are involved, plot number 2282, 2284 and 2285. Now
yes.
2282 is the malad the clear land. Now 2284 is the Borga land and malad the another plot malad 2285 malad the left side.
It's away from the,
And malad kindly consider my malad in affidavit malad paragraph 16.
in between the entire stretch is Borga land. The
Malad
yellow,
the-
pink, green,
Others riots.
other riots.
Other riots. Malad this is only malad the yellow colors is the malad land belongs to the petitioner.
So even if this was not Borga land, they
Not-
are
and
not contiguous.
Malad 2284 is the Borga land.
Even if there was no Borga there, you wanted 3 contiguous lands, isn't it?
See, lands are not contiguous.
But it was your proposal, you accepted it.
Malad the petition is
Since
this.
the beginning, you were aware that these 2 lands are side by side, they are contiguous, and 2285 is away from these 2 lands.
Malad 2284 is the Borga land. Malad in the Borga land, malad the state cannot malad the take the Borga land for the purpose of the project. But this is the difficulty. Malad kindly comes to malad page
If you
7.
do not take Borga land, you can take 2282 and 2285.
Malad to that effect, malad proposal same. Malad that they said, malad that you have to malad the take. Malad I want to keep all the 3 lands and the for the purpose malad setting up a rural health center.
The petitioner wants to get rid of the Borgadars actually. Yes,
But
how
the-
do you explain this?
My lord, this is no at all Borgadar. My lord, kindly see their affidavit, page.
Malad page 16 of my affidavit, I have annexed the record of rights, which shows malad the land is malad under the Borga cultivation.
Co-sharers, that's not a difficulty because the petitioner wants to donate his share.
His share,
portion.
malad I have malad
So
the
first point is not difficult.
we have stated malad the total area of the land and what is malad the petitioners malad the
That's perfectly all right.
Well, main problem is the one
Borgadar.
middle is the Borgadar and the another plot is the between the last plot there are several persons land is there.
That you were aware from the beginning when the proposal was given. You have not consented to the proposal without seeing this picture. The state was aware all throughout. Maybe Borgadar you are not aware, but these two lands being apart from each other, you are aware.
Well, kindly
You
consider.
cannot take that plea now.
Now, kindly consider point number 3. 2 and 3. Kindly consider this.
Borgadar is fine. Point number 3, you are aware all throughout. You cannot take this point now.
Now,
The only issue is Borgadar.
Borgadar and the next page. Point number 4. Pursuant to my lord's direction, the hearing was conducted. On that hearing, this is the proposal from the side of the petition.
Yes. The petitioner wants it to be used for a public purpose.
Yes.
That is perfect. The only issue is, yes, Borgadar. Your record of rights say that there is a Borgadar. How do you?
I'm satisfying. When come to paragraph page 32 of the affidavit, page 32 annexure.
Yes.
It is handwritten Xerox type Xerox copy. Bhumi or Bhumi Samskar Adhikari, Mahasamipesu, Nondigram 1, etc. Come to the last part of the report. Ukto dage 2284 মোট জমির পরিমাণ 55 তার মধ্যে 26 অংশে 15 জমি 18 খতিয়ানে অনিল বর্মন নামে রেকর্ড হয়েছে। আরো দেখা যায় যে জনৈক ভূতনাথ বর্মন পিতা চন্দ্রমোহন বরগাদা হিসেবে রেকর্ডভুক্ত রয়েছেন, কিন্তু উক্ত রেকর্ডভুক্ত বরগাদারের নেক্সট পেজ কোনো সন্ধান পাওয়া যায়নি এবং উক্ত দাগের 15 জমি পূর্বে কয়েক বছর যাবত মৃণাল বর্মন চাষ করছেন টেম্পোরারি। তাহলে এই therefore this is the report that there is no Borgadar in fact in the name of Bhutnath Bormon. This is first.
Found. So you have to go in for correction of records.
My lord, correction of I on the last week this question arose by my lord. I bought the book. I refer section 50 and as well as of the Land Reforms Act and also rule 21. Whenever an inspection has been done by the RI office, it is their duty to rectify the record. And I have got the notes of cases. Kindly see.
Hello, my learned friend is
This
relying.
portion cannot be dealt with by this court at all.
No,
The RI office has not done it. You have to file an application.
no. I also sent an application also. I have application also on
So let the
24th.
matter wait.
24th.
Records corrected because the government appears to have no other issue.
My this
This is
is
the Borgadar part.
my lord. I have
My
last
learned friend is
last-
relying page 32. Kindly see the report regarding 2282. উক্ত দাগে প্রায় 10 শতক পরিমাণ জমিতে পুকুর রইয়াছে। Then again question of water body, filling of the water body will come.
and also my lord
He is relying
in my reply at page 26, 25, 26.
Two 2282 is recorded as a water body.
2284.
2282,
2282 no 28 not recorded.
page 32 of the affidavit.
Is 32.
যেটা আপনি দেখাচ্ছিলেন ফার্স্ট পেজটা দেখান না, যে 32 যেটা দেখাচ্ছিলেন 2282 রিপোর্ট।
222 is clean land. There is first land of the picture file today. They are saying 2284 is under Borga. And not only that, kindly,
It's recorded as a water body.
no, it is clean land. It is with the agricultural.
40 decimals. Now, the outer portion of it,
10 decimals.
10
is
decimal
what
has been the
recorded as, yes.
that is one of the, this is the physical, physical is a water body.
No, up to this date, only they are disputing about the Borga, record Borga. I am answering only the case of Borga. Others part they never disagreed. 2284, they will kindly come to the my annexure at page 25. My affidavit, kindly see.
It's water body.
No, not water body. My client is present here,
It's recorded
not
as
water body.
Sir,
No, not water. It is under personal cultivation of the petitioner from long ago, from this childhood.
record of rights of 2282.
2282. 2282.
Is it annexed? 2282 record of rights?
Yes. Two 2282 at page 13
Of the affidavit.
of their affidavit.
This is Jol.
This is recorded as Jol, but this is actually is under cultivation of their from since long time and never disputed by them.
How? They don't need to dispute. The law disputes it. Where is the conversion document? You cannot hand over disputed property. The state will not take
There is
it.
nothing dispute, my love. I see Borgadar, the law of Borgadar is not an incumbents. Kindly come to page 9 of my affidavit. I explained it. Page 9 of my affidavit.
You have two issues to solve now, sir. One is Borgadar, another is this Jol.
First thing is that it is not Borgata, and number 6 is Borgata is not the incumbents to the land. Even if you recorded Borgatar, there is no incumbents to taking the gift by the government. Because Borgatar is only hits the point time of preemption. If in the case of preemption, Borgatar has only right to purchase priority purchase. But except that,
To be the discretion of the state. You cannot insist the state to take a land which is occupied by Borgadar. It has to be free from all encumbrances. Why will the state take responsibility and get into a suit against the Borgadar?
no Borgatar. My lord, come to my annexure 525.
One document,
Kindly
there
see.
is no Borgadar, and it is in your physical possession.
Kindly see page 25 of my application affidavit. See, therefore joint inquiry page 25 of my affidavit. Page 25 of my affidavit. Affidavit, supplement affidavit, reply to their affidavit. Page 25. This is the report filed by the revenue inspector and sanctioned by BLRO. Second page, therefore a joint inquiry was done by me along with Sri Anil Kumar Burman, that is content petitioner, and Sri Manik Kumar Khatwa. Amin on 10/4/29, it reveals from the inquiry that Sri Anil Kumar Burman has possessed over the below scheduled land for many years. This is report of the government. So and see plot number 2282, 2284, and 2285 was there.
You are aware of
That
the
is
position
possession
of
through
law.
Possession.
Borgadar, not
Absolutely. You what
Possession.
you're submitting, sir, please. You are aware that possession can be also through a Borgadar. This possession doesn't necessarily mean his own possession or physical possession. How do you define possession? These are all settled principles of law. We need not spend so much time on this. Two issues before you, sir. One is it's free from encumbrances, no Borgadar, it is in your physical possession. Secondly, you say that you are cultivating a land which is recorded as Jol.
Jol
Why
is
are you doing that?
Jol is the low agricultural land. The port's total area is 40.
It's
He's
yes, 10
cultivating
decimals
10
is
years,
water
10
body.
has been become a water body at present.
Low areas there, what is the inconvenience of taking the gift? And while if public does not donate, if public does not donate the land, there will not be any improvement. And this is a pious purpose of the petitioner that he has suggested for many.
Donate a water body for however pious a purposes.
Everything is pious. See, I have stated in my application by paragraph 8.
Will you
Yes,
come back with the necessary
that
responses?
the government authority would not have shown so many obstacles in the matter of receiving the gift of land. In any event, my approach is to give the land for intended and beneficial purpose for public. There is an open fact that many schools, hospitals, public places even have been established in name of donor of the land. Like for instance, Nilotan Sarkar Hospital, Shukla Garden Hospital, all everything, Monando College, everything has been given by public person.
There is no dispute with regard to your pious intention. No dispute
Hmm.
at all. Government is going to happily accept it if the land is free from all encumbrances. That is the only term that is used. So please come back showing that you have made a correction of the record of rights. There is no Borgadar. It has to.
Say
be
mine,
put
I
in
will come
place
back.
before
I will come back by further affidavit.
the state is ready and willing to accept your lands.
My lord, record something so that I can be given, directed that so far this hearing has been done.
It is submitted on behalf of the alleged contemner that the state is unable to receive donation of receive and accept donation of plot number 2284 by the applicant petitioner, since the said land is under possession of is under possession, the said land is in possession of a Borgadar as reflected from the record of rights. Stop. Also, comma, 10 decimals of plot number 2282 is recorded as a water body and cannot be utilized by the state for public purpose for which the land is intended to be donated. Paragraph. Learned counsel for the applicant petitioner submits that there is no Borgadar in plot number 2284 at present, and he has taken necessary steps for correction of record of rights to that effect. Stop. Learned counsel seeks to take instructions with regard to existence of the water body in a portion of plot number 2282. Paragraph. Will you come back after vacation?
After vacation.
Because correction will take some time.
Yes, my lord, say there is never any Borgadar. I submitted.
Yes.
There is never any Borgadar. There is just not present at present. Borgadar need not. There is never any Borgadar. No, this is a fake record. Only thing is that not rectified.
Oh, you can't apologize. You can at present problem. Learned counsel for the correction of record of rights. There was no Borgadar. There was no Borgadar at any point of time. At present, at any point of time, and the petitioner has taken learned advocate. And the petitioner has taken necessary steps for correction of the record.
So kindly record my
Yes.
denial, I am denying since the record.
After line, the contention of the petitioner is denied and disputed by learned counsel for the alleged contempt. Paragraph. I'll let the matter appear under the same heading on 23rd November.
23rd, my lord.
Please do the needful in the meeting.
Yes, I already applied for rectification.
Yes.
Item 7.
My lord, this matter, my lord, I am filing the affidavit of compliance, my lord. Kindly have a look.
Petitioner
Well, I am for the petition.
received a copy.
Well, just now I am.
You want to go through this and come back?
Yes,
My lord, kindly see the annexure A, my lord.
Learned counsel wants to, you have not served an advance copy as usual.
My lord,
So
I have
learned
not
counsel has
served
to go through this and come back.
because this is, my lord,
Affidavit
unless
of
without
compliance.
court's order, I cannot, my lord. This is the contempt. This is between court and when your lordship directed.
Without court's order,
I
you
have
cannot
already
serve an
given.
advance copy.
My lord,
Without the court's order, you cannot serve an advance copy. Where is such rule?
my lord,
Please do not make such submissions, madam. You have not served that.
since it is a contempt, that's why, my lord. I have no others.
Affidavit of compliance submitted on behalf of the alleged contender is taken on record. Paragraph copy of the affidavit is made over to learned counsel for the applicant petitioner in court this day. Paragraph on prayer of the applicant petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th October.
বারো দশ এই সব পড়ে যাচ্ছে তো। সব পড়ে গেছে
Item 8.
And I beg to appear on behalf of the petitioner, my lord.
Yes.
My lord, this is my affidavit of
State,
service.
Mr. Dev.
This is my affidavit of service. My lord, this is against the rejection of my claim for compensation on the ground that on the basis of a record of right.
On the basis of record of.
Record of right changed in the name of the State Department as well as on the name of the National Highway Authority. I don't know, my lord, that I have never came across such a situation. Then National Highway Authority became the riot under the West Bengal Land Reforms Act. Anyway, my lord, kindly turn to my whole grievance is this, my lord, how they time and again, one after another, I moved before this court and they changed their stand on the basis of their on the basis of the order, just to frustrate me. Now, lordship, kindly turn to yes.
First point, whether the petition is maintained.
Huh?
I say,
Let us hear the interpretation. That
Yes,
Yes.
kindly.
my lord, if your lordship will see the last, what is challenge, my lord, that is the portion. And my lord, and my lord, 315,
Page.
315.
Start from page 312. Relevant page is 300.
My lord, the case is put up today for hearing. The last, the learned advocate of the behalf of the petitioner and performer respondent are present. The learned advocate presents the arguments in favor of their claim as the landowner of the suit property which are based on RS record. But he cannot produce any document of LR record. In the meantime, this office has received the LR record and suit plots from the office of the SDLRO Asansol, which are made a part of the proceeding. The observation is as follows. The Honorable Court directed the undersigned to revisit the case in the light of the observation made in the said judgment, as well as the order of the coordinate bench in WP number Ato. Gone through the judgment of the Honorable Coordinate Bench, where Honorable Court clearly mentioned that it is for the writ petitioner to establish their claim with relevant document as indicated earlier. During revisiting the case, the undersigned feels that the LR record is a relevant document to ascertain the recorded owner of the suit plots at the time of acquisition. Because of the said acquisition proceeding was initiated in the year 1976 and 77, but the writ petitioners produce all documents which are issued in the year 1969, that is RS record. After scrutiny of updated LR record received from the office of the Asansol, the status of the record, my lord, vested land. All are vested land, last 2515 National Highway Authority of India. Therefore, said LR record reveals the most of the LR plots against RS plot noted above are vested in the state, except plot number 2125 corresponding to RS plot number 2515, which is recorded in favor of the National Highway Authority. So it is clear that the writ petitioner were not the owner of the suit plots at the time of acquisition. Observing all the undersigned concludes that the writ petitioner claim as the landowner of the suit plot as well as the claim of the commissioner are not established, hence the petitioner representation is
considered and rejected. What is the wrong in it?
The vesting is shown only after at the plots were acquired.
No, my lord.
No, my lord.
Interrupt.
The-
My
এক
learned
মিনিট
friend
দাঁড়াও।
cannot argue on the basis of the writ petition, merit of the writ petition. My writ petition is maintainable whether want of jurisdiction or part by the law. He has not
I
argued a single point on this.
My lord, I have want of jurisdiction. My lord, I submit before your lordship that is the want of jurisdiction. As the plot vested according to the West Bengal Estate Acquisition Act. That is according to 2R, my lord. That is the prescribed act, my lord. If the prescribed act is the West Bengal Estate Acquisition Act, and according to 6 and R8, my lord, they have not any jurisdiction to come before your lordship.
Vested according to the Estates Act.
West Bengal Estate Acquisition Act.
Please show me the documents.
Yes, my lord, I will show you all the documents, my lord.
Let a report be filed.
But I sorry to say all this thing. On the self-same issue, this is third time I moved this application and no one raised this point. Now, my lord, my learned friend is saying that vested under the Estate Acquisition Act. Kindly turn to the.
Then the
and it's-
matter was, this is an order upon reconsideration.
Yes, my lord. In reconsideration, it is seen, my lord, that all the lands are vested in the West Bengal Estate Acquisition Act.
It is by the authority that.
Now,
it is
my lord,
vested.
West Bengal Estate,
My lord, can
if
you-
the land was, a minute, if the land is, my lord, vested in the West Bengal Estate Acquisition Act, how, my lord, this court has the jurisdiction to pass
No,
any order?
That's why I'm asking for
Yes.
documents. That's a different issue.
Yes, my
But
lord.
this is, first there was a consideration, then there was a reconsideration.
My lord,
So
previous, my lord, my learned
Previous
friend
two
of the previous,
proceedings, the authority has remained silent over this issue. That is surprising. That
my
is
lord,
what I want.
that is, if they are not, my lord, I have the report to this effect, my lord, if your lordship, I can give one report to my learned friend, my lord.
Mr. Pan, let Mr. They come back with a report in this
just, my
connection
lord, one
because
thing, just one thing. I like to draw your lordship kind attention to any page. Kindly turn to page 111. Just for a moment, my lord, page 111.
111.
I am surprised that how this can be said, this document can be said is vested to the state under the West Bengal Estate Acquisition Act. Kindly turn to my lord the certificate.
page 111, yes.
Yes, kindly turn to the certificate.
111. Certificate.
This is the certificate, my lord, issued by the under section 44(2)(a)
Yes.
and not revision under section 47 of the Estate Acquisition Act. Now, this is the finally published record of right. And my learned friend is saying that my estate acquisition vested under Estate Acquisition Act. But this is the retained land after section 6. Kindly have a look at them, my lord, the section 44(2)(a) once.
My lord, I have with a report, my lord, if your lordship will.
Report will not, my lord. Kindly have a look at them, my lord, that just a bit. Kindly have a look at the section 44(2)(a).
তুমি যা বলবে তা তো আর হবে না। My lord, I filed the report, একটু দেন না দাদা। এই নাও। এই ইয়ে আমার তার একটা আছে, তুমি নিও, পরে নিয়ে জেরক্স করে নিও।
Yes.
An officer specially empowered by the state of government may, on application within 9 months on his own motion within 60 years, from the date of finally published on the record of rights order from date coming into force of the West Bengal letter, revise and entry in the record if finally published. So this is done after the revision even. And my lordship, kindly have a look at the rule 4 of the West Bengal Estate Acquisition rule. My lord, let me go through the report, my lord. I will come back with the report. And my lord,
Yes,
I will
please
come.
do that. Yes.
Yes.
My lord, whether my learned friend can argue on the point of Estate Acquisition Act before your lordship.
Huh?
I submit before your
Where is the
lordship
bar?
that he has not the.
Where is the bar?
This is not the court of my lord, that is the West Bengal Land Reform Tenancy Tribunal. He must go there. According to my lord, there is
Estate Action
in
does
every-
not cover by the West Bengal.
no, my
Land
lord,
Reform
he
Act.
can't do that.
Mr. De, learned counsel can argue on the limited issue.
Yes.
that
Only
this
issue,
is
my
not-
lord.
this is
That is
not-
only issue
I am
that
not
the
the-
West Bengal Estate Acquisition Act, the land was vested, only issue. Nothing else, my lord. I may not want to go into that. My lord, only issue that land was vested to the West Bengal Estate Acquisition Act, and that is as a, my lord, 2R, according to the provision of 2R, that is a prescribed act, my lord, and
If it is vested under the SSA acquisition,
yes,
then
my lord.
of course, 2R comes into.
Yes, my
play and
lord.
This court
This-
cannot deal with it.
Lord, that is not my challenge against the.
Now, my lord, he
vesting
said,
under the West Bengal
my
Estate
learned
Acquisition
friend
Act.
said
I
that
am relying on the
that vesting
document
is not the vesting of the West Bengal Estate Acquisition according to the 44(2) and anything else, my lord. That argument is not, my lord. He can't argue this, that in before your lordship.
Let learned counsel come.
Yes, my lord. এই তুমি যদি এটা নাও, এটা জেরক্স করে আমাকে দিয়ে দিও।
Affidavit of service filed by the petitioners and report submitted on behalf of the state respondents are taken on record. Paragraph. Copy of the report is made over to learned counsels for the respondents in court this day. Paragraph. For the petitioner and the NHAI, sorry, petitioners and the National Highways Authority of India in court this day. Paragraph. On prayer of the petitioners, the matter is adjourned. Paragraph. Let the matter appear under the same heading on 12th October.
My lord, may, I understand, my lord, this is the report on the writ petition itself, not on the basis of the maintainability. Kindly clarify this thing from the order, my lord. If this is on the basis of the report. on
My
the
lord, that is
basis-
maintainability and anything else, my lord.
But it
That
will
is-
suffice my
My
purpose.
lord, maintainability first. Maintainability.
It will suffice my purpose. This is a report on the writ petition. My lord, relevant.
If necessity, my lord, at the
By the. Oh, taken
কত
on
তারিখ? 12
record
তারিখ?
পরে একটা দিন, taken on recorded পরে. Learned counsel for the state respondents, comma, by submitting the report, comma, challenges the maintainability of the writ petition on the ground that the plots in question have been are vested in the state in terms of the West Bengal Estates Acquisition Act. তারপরে copy of the made over.
My lord, sorry, my lord, to interrupt your lordship, my lord. In the meantime, if required, my lord, I file my exception to the. Yes.
On prayer মাঝে ঢোকান, on ওটার পরে, service এর পরে. On prayer of the petitioners, liberty is granted to use an exception to the report, comma, if required. Next.
Considering the age of the petitioner, your lordship was kind enough to upgrade this matter. Let it be at the top, my lord, if your lordship is kind enough.
It is appearing.
Kindly, there is a.
Matter when new motions are taken up, it will automatically come at the top.
Kindly, make it. Because consider the only age of the petitioner, age is 82 years old, my lord, and he is suffering.
Fairly at the top.
Deeply obliged.
Next.
Nine. Next করলে হবে?
My lord, I am for the petitioner. I have copy upon all the respondents. My lord, this is AVW service. My lord, kindly have a look to page 15, my lord. My simple prayer for consideration of my representation for compensation, my lord.
Or
Page 50. Yes, my lord. Page 15, my lord.
take the microphone, please.
report, my lord, government has decided to direct purchase of the property. And you kindly.
Take the report. Have you received a copy of the report?
No, my lord. I'm the giving.
Last but one page, my lord, kindly see. Later dated 21st August 2023.
Yes, yes.
Yes, my lord, I understand.
So how long will you take to complete this purchase?
Has 1 month, my lord.
Direct purchase cannot be done in 1 month, you are aware. sir.
This is only sale, my other proceedings was already completed, my lord. Only sale, my.
Yes. let the
Sale and
state respond.
purchase.
Your lordship kindly grant some time to the department, they will do in the meantime. That is reasonable, at least 2 months' time may be required. Subject to lordship pleasure. সব হয়ে গেছে complete.
My lord, everything completed, only, my lord, transfer of property, my lord.
Yes,
According to the present act, transfer of property, my lord, only, nothing else, my lord. Sale
Property is under in the hand of the government.
your
The
land
money,
has
he
been
will get money.
by the government,
He will get money.
no acquisition proceeding, they want to directly purchase.
Purchase, my lord.
Are you agreeable to this?
No, no, my lord. My lord, for any time, my lord,
Yes.
time maybe 1 month, that is I agree.
Do you agree to this proposal?
No,
of
my
direct
lord,
purchase?
no, my lord.
So what are you asking for?
Only the time maybe, my lord,
Time for what?
for payment of compensation within 1 month.
Sir, please try to understand. You have asked for compensation.
Yes,
Compensation cannot be paid without acquisition.
Yes.
When there is no acquisition, compensation cannot be paid. It has to be acquired first. The government proposes direct purchase of the land. Are you agreeable to it?
I'm agreeable, my
Do
lord.
you agree to it? So all this while you were saying no.
No, my lord, I'm agreed, my lord.
The reasonable time may be given, my lord, that proceeding will be completed.
Who will do this? The district magistrate?
No, my lord.
The direct purchase,
But this is letter is written by the executive engineer, PWD, Barasat Division.
district
District
magistrate. And I think it will be better to rope in the first respondent also. Secretary PWD, Government of West Bengal. So the district magistrate will be the competent authority? So let the district magistrate be directed.
Response number
Because it's
2.
under the issue of the district magistrate.
Response number 2, and
Yes. The petitioner. Affidavit of service. Affidavit of service filed by the petitioners and statement of fact submitted on behalf of the state respondents are taken on record. Paragraph, the petitioners complain that their land has been utilized by the state without acquiring the same or paying any compensation to them. Stop. Paragraph, it is the petitioners submitted a representation before the concerned authority seeking initiation of acquisition proceedings and payment of compensation under the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Representation on 22nd May 2023 করুন। Comma, which is yet to be considered. Paragraph. Placing reliance upon the statement of facts submitted on behalf of the respondents, comma, particularly a letter issued by the executive engineer within bracket PWD, comma, bracket close, Barasat division to the chief engineer within bracket planning, bracket closed, comma, PW within bracket roads department, comma, Government of West Bengal on 21st August 2023, comma, Learned Counsel for the respondents submits that the government is agreeable to purchase the plot of the petitioners utilized by them by direct purchase policy. Stop. The petitioners agree to the said proposal of the government. Paragraph. In view of the above, comma, nothing further remains to be adjudicated in the writ petition and the same is accordingly disposed of. Paragraph, however, comma, the second respondent is directed to initiate process of direct purchase of the plot in question from the petitioners and take and conclude the same, including payment of adequate valuation of the property to the petitioners within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of which action?
Item 10.
But I am for the petition. Nah. টাকা দাও আগে।
আপনি জেলা পরিষদ
Our petitioner before your lordships are the landowner where the Jila Parishad of the Birbhum started construction over the petitioner land. Without acquisition of the land, forcibly they want to construct the road. We register them. But at that time, they did not do anything. Not we have filed a representation in different authorities. They did not take any steps. Thereafter, my petitioner came before this Honorable High Court. High Court has passed this order on 27 March 2019. At that time, the Jila Parishad of the Birbhum, they have said we stop the construction of the road. Therefore, your lordship kindly see that order. Only especially order is passed. I am not passing an interim order as they have said. We have already stopped construction over the land as without acquisition that is going on. And thereafter, Miller, they have already completed the road in spite of the undertaking before this court.
Who is appearing for the Jila Parishad?
I am happy. The land,
And see
the
the
road is,
photograph.
the scheme is the Pradhan Mantri Sadak Yojana. From Kacha Road to the Pakka Road.
Maybe, what about the compensation?
Compensation, well, state is the compensatory authority, not the Jila Parishad, madam.
But one thing,
State should take about that.
may I
Answer about
answer
that.
his
Who is
question?
appearing for the state?
And the state, my lord,
Yes.
in case of Pradhan Mantri Sadak Yojana. we are
If it is Pradhan Mantri Sadak Yojana, it cannot be a new road. Where there is a road of Kacha road, they can convert into a black top.
But
He
my
cannot.
But my instruction is that no road has been encroached.
Yes, Madam. If they have said no road have been encroached, not I am sending, this is the photograph. All the crops, they have damaged without giving any
Yes.
crop compensation.
And they will grow crops in the road itself.
Yes, yes, yes. Not kindly see the photographs.
That is
Yeah.
also there.
Kindly see. If they said this is
Willingly
the,
think that it is my land.
this is the Kacha road, the why the crops are there?
Yes.
It is not that there is a road. They are forcibly damage our crops and
Let them
Make
prove
up
in
the
civil
road.
court, my lord. It is their land. It is not their land, my lord. That is wrongly interpreted. I have taken an action.
all those fortune.
I have taken it. Yes, for check, go to the civil court. We have
No.
done a wrong. Go to the civil court. That is my land. What happens, my lord? That was a Kacha road. Kacha road was there for long. And thereafter, in the side, also Kacha road, there is some road of the government. Now they grow their crops and their own sweet will they do so. Thereafter, they will show that is plantation has been done. This is happening, my lord. Now, if they want
I
to
have
go,
shown the photographs. They cannot deny it.
so within
This
only
is our,
showing that.
this is our agriculture.
It's not proof title.
Yes.
Okay.
Title should
Well,
be.
they have to. Well,
Denying your title on the plot, land in question, the road.
no, they have not denied any title.
I have not got any.
No,
spot
they
for
have
property
said,
owner.
this is the road,
Property
Kacha
owner.
road.
Want to come back with a report?
If your lordship so desires, I will go. I have to. Otherwise, if your lordship allows me to file an opposition, I will file.
Opposition will not be necessary.
From 2019 to the opposition.
As your lordship.
Opposition is not required at all. Why don't you come back? Even if
I can, but state would.
State also come back.
Nothing to do in this matter, and because in this scheme, state has no scheme for acquisition at all. If the villagers is allowed to make the construction of road, then road will be constructed.
What
This is the
happens?
scheme.
What happens, my lord?
This is the
Allowing.
Well, what happens?
The petition is that you have taken away the petitioner's land and you
No, I have
constructed a road.
Now, it is a Pradhan Mantri Sadak Yojana, madam.
Yes, in this scheme.
Mal,
If the
kindly-
And now, my lord, what happens?
Kindly report
They-
be call for after inquiry of the
Yes, yes,
field.
that I will do. Madam, I am
After
sorry.
inquiry of the field, a report is to be given to
Yes,
your
I will
lordship.
do. Madam, one thing, my lord, they have waited. Road is constructed. That it does not.
Not
done-
waited.
That
They
is
have
that is
said.
not done within 24
no.
hours.
Well,
Undertaking by you.
Well, they have undertaken before this court. Yeah, we will not have started our construction.
That is recorded in the earlier order.
Yes, earlier order.
That was done long before.
At that time, he was not up here.
Whatever, doesn't that amount to
I
contempt?
will come with a report, my lord. hereafter.
Doesn't that amount to contempt?
I will come with a report.
The
But that is
undertaking
better is
recorded.
that
Actually, they have
Go- go-
violated
go
the
for
order
a
of the
civil-
court.
this is my land. Don't go and approach. That would be the better approach, my lord.
That is,
In any manner, I will come with a report.
Pradhan Mantri Sadak Yojana is to be constructed where there is a road.
Yes,
By
we have
force-
done it. We have done it within in a road. That I'm admitting that
By
I've done
force.
it in a road, not in your land.
It is
This is
submitted
the-
Yes, picture. I can come with a picture.
They've come
I will
with-
go in my field. It's in own field, and we'll get a picture.
Heard, please come back. It is submitted on behalf of the petitioners that despite submitting an undertaking before this court to the effect that construction of the concerned road has been temporarily stopped due to pendency of the writ petition the same being recorded in order dated
Maya,
27th
Katuna.
March 2019,
তোমার জমিগুলো তো নিয়েছি
has
গোটা গ্রামে
completed construction
কাঁধে
of
হাত
the
দিয়ে
road
কাঁদছে দেখবে
by encroaching upon the petitioner's land, is a core apostrophe. Paragraph, learned counsel for the Jela Parishad seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 13th October.
October is not be possible, man. Let it be after the vacation.
Before that,
Sufficient time.
back to that.
13th October.
Back to that.
Where will I give you another week? 17th? 17th.
মেরেছে বসে বসে কাঁদছে
পুজোর আগে একটা ফিস পাবে তো?
না এমন মেরেছে বসে বসে কাঁদছে
ও কাঁদাটা তুলে নিয়েছো? এই কাঁদাটা তুলে নিয়েছো? He had taken a picture of the crying also.
Picture of the
The person crying there.
Whose field is going filled up.
Mr. Bandyopadhyay is leading me.
where is Mr. Bandyopadhyay?
He is at court number 5 miles. He has come early morning.
With the field inquiry, report is to be filed with the field inquiry. That the
The field inquiry will have to
Yes.
be done. Otherwise,
that is the
Please substantiate your cause.
substantiate.
Yes,
I have to substantiate.
they will give notice to us below and at the time of field inquiry.
The field,
We will show that field.
but field inquiry will have to be done by the BLR. Then that
The
is a
BLR will do it. Whatever may be, BLR will do it and submit the report.
BLR will
I-
come and BLR. He is a very busy person.
Oh,
They will take some time. Yes.
no, there is no time. Take time. Court order, by court's order it will.
I can
Another statement. This is 7th time, my lord, they are filed notice.
Yes,
This is 7th time. Your lordship directed to
Further instruction.
You also directed me to take instruction whether at the time of field inquiry, the petitioner was present or not, my lord.
Yes.
But we have taken instruction, my lord. My lord, they were present, my lord.
The document,
The document, my lord, on my lord, last occasion, I filed my report in that report, we have also annexed, and here I have
that
also.
report only the
This is-
inspection
this
report
is the-
was there.
We have no other, my lord, report, my lord. This is the field inquiry report, my lord. Page, my lord, 3 of my lord.
Report is not prepared on the field.
Yes,
Report
my
is
lord, this
prepared
is my case.
subsequently.
No,
This is
my
my
lord, no,
case.
my lord.
Kindly see, my lord.
This is the
page
field
10 of the
inquiry.
report.
This has been, my lord, field inquiry has been, my lord, made in the presence of the petitioner in the field, my lord. And on that date, my lord, that is on 15th of June 2018, a report has been prepared on that date, my lord, in the presence of the petitioner.
Inspection reports cannot be prepared on the field.
Yes, my lord. And
You
my
do
lord,
not have a typewriter, you do not have a computer.
and my
in
lord,
the
only my
field.
lord,
It is always prepared in the office subsequently.
yes. And this
the-
was
but
made
the-
ready, my lord.
That's why in the field, a field note is prepared, where
There-
presence of the parties are recorded by way of their signatures.
But apart from that, no other document is there.
Your
Hold
lord.
fresh inquiry, field inquiry. Upon
Yes, my
service
lord,
of
this is
notice
my
to the
prayer, my
petition. If you have no other document to substantiate, you have to hold a fresh inquiry.
And these
Kindly
documents
direct, my
are
lord.
ready made, my lord. Kindly see page 10, my lord.
On that day, like
I
that
have-
is the not, my lord, bottom, the head of surveyor signed on
These are all
15th of
cycle
June.
style documents
Yes,
where
my lord,
only
yes,
the
yes,
gaps are filled in.
yes, my lord.
You are also aware, Mr. Bhatt.
Kindly
Kindly
see
direct, my
ready
lord, fresh
before the
inquiry.
inquiry. Let them press inquiry. If there is damage, I am entitled, otherwise not.
There is damage compensation has been calculated on the basis of field inquiry, everything has been done, my lord.
That field inquiry is in question. You cannot show a document that the field inquiry was held in presence of the petitioner.
Yes.
The report bears the signature of the petitioner. Reports are not prepared on the field.
We have no other document. Kindly direct on the fresh, my lord.
And the document was downloaded prior to the field inquiry.
Yes, my lord, this is my submission.
Document was downloaded on 20th December 2017. Field inquiry was held on June 15,
That is not
2018.
downloaded. That is whether file name, my lord.
No,
This is
my
a
lord, kindly
file
see-
name, my
I'll
lord.
kindly
For the
see, my
last one we
lord,
have submitted.
case
my lord.
number, damages, assessment.
This is the file name, my lord.
Page 10.
Page 10 of the report.
Yes.
Estimate awardee, WP number so and so, last damage requisition on 20th December 27. Prior to field inquiry. How it
This
is
not-
possible, madam?
This is not file name only, my lord.
This is file name, this whole thing. How is it possible?
But
Please show me another document where there is such a big file name. How can this be file name?
then I shall file, fresh inquiry. my lord.
And field inquiry was held on 15th June.
Yes.
In June, my lord.
Even if I go by the signature, the last signature is 26th June.
Only one
Yes,
signature
yes,
is on 26th June, my lord. Executive engineer.
engineers.
And other than that,
Is
all
this
are-
the petitioner's signature in the?
Yes,
report?
this subsequently, yes, this is my signature. But it was taken subsequently. But cannot be possible ready in the field, all cannot be ready.
And this document also doesn't record that it was held in presence of the petitioner. The
only
report
signature
actually
is
should
there.
say
Only signature is
Only
there.
as landowner,
Yes, ma'am.
not as his presence.
Whatever is on the record, I cannot go beyond that, my lord.
So let there be a fresh field inquiry.
Yes.
Upon notice, madam.
This is for damage
Yes,
compensation.
only damage, yes. Requisition I have been paid.
The primary grievance of the petitioner is that in assessing damage compensation payable to the petitioner, comma, the purported field inquiry held by the authority was behind the back of the petitioner, and no opportunity was afforded to him to remain present during the field inquiry or participate in the assessment. The field inquiry report submitted on behalf of the respondents bears the signature of the petitioner. Stop. But there is no endorsement in the said report that such signature was made by the petitioner at the time of the field inquiry on the spot itself. There is no field note annexed to the inspection report to suggest the presence of the petitioner at the time of the field inquiry. Surprisingly, the report demonstrates that the document was downloaded on December 20, 2017, whereas the allegedly joint field inquiry was held on June 15, 2018. Stop. Paragraph: in view of the above, this court is inclined to hold that a fresh field inquiry is required to be held in presence of the petitioner / his authorized representative in order to ascertain the damage compensation payable to the petitioner for utilization of his land. Paragraph:
Damaging the land during acquisition.
But they have not subsequently released, my lord, not utilized.
Yes,
Or damaging the land during the period of requisition.
কি বললাম? Damage compensation
Caused by
payable to the petitioner for the damage of the land during the period of requisition. Paragraph: accordingly, the
well, it will be better your
Field
lordship
inquiry
directly
/
on 4.
joint inspection report is set aside / quashed. Paragraph: who should be the authority to hold the joint inspection?
Respondent of 4, man.
That's one of 4 and 5 joint.
Both.
4 and 5.
Both together will hold the joint inspection.
Recording body.
In the presence of all the parties required, my lord.
Yes, but who will?
By special learning of respondent of 4, my lord.
A joint inquiry should be held.
It will be held in presence of all concerned.
Yes.
Paragraph: the fourth respondent is directed to hold a fresh joint field inquiry in presence of all concerned, including the petitioner, and assess the damage compensation payable to the petitioner within 1 month,
Correct, 2 months. Puja is coming, my lord, we have to be informed.
within 2 months from the date of communication of this order, comma, in accordance with law. This was the
Make-
decision taken by the authority should be communicated to the petitioner within a week thereof. Disposed of which.
Want to make payment, my lord. If there is damage, let them pay. If it is found there is damage, let them assess and pay. Otherwise, they will not pay, my lord.
Within another month.
Yes.
ওখানে একটা line add করুন। The damage compensation as assessed by the authority be disbursed in favor of the petitioner within a month thereafter.
Get
ওই communication এর পরে হবে।
disposed of.
Disposed.
If there-
Lordship, item 12, I appear for the petitioners.
Service complete.
Lordship, this has come up after a restoration, Lordship. They were served at that point of time, Mr. Suprabhat Bhattacharya and Mr. R.N. Datta used to appear. So there's a direction.
Will you serve a fresh notice and come back?
I can do that, Lordship.
Since on the date of restoration also.
May I
they
just
did not
serve
appear.
it? May I serve a notice upon the general government pleader directly, Lordship? I don't know whether they are still available in the
Please
panel.
do that. Please do
Lordship may kindly indicate it that.
None appears for the state respondents. On prayer of the petitioner, liberty is granted to serve the office of the learned government leader afresh and file affidavit of service on the adjourned date. Will you come back after vacation?
Lordship keeps it this side. This is a, Lordship, I'm just seeking parity of an order. It will just take 2 minutes of your Lordship's time.
Paragraph, let the matter appear under the same heading on 13th October.
I am so grateful, Lordship. So grateful, Lordship.
Wait, please, Ross. I put the petition, my lord. Have you service to me?
Yes. State.
Under the petition before Lordship, my lord purchased the land in 2013. My lord, that time, my lord, the petitioner.
Have you served the municipality?
Yes, yes. Mr. Somiran Mondal, I also sent a message to him
But
from
where
here,
is he?
but he's not has not come. Mr. Somiran Mondal is applying for the municipality.
Yes, please continue.
My lord, he purchased the petition, purchased the land, my lord. Thereafter, my lord, Estimate 5, my lord, issued NOC for conversion. My lord, there is answer P2. My lord, petition thereafter, my lord, applied for change of character of the land under section 4C of the West Bengal Land Reforms Act. Before the respondent 4, my lord, and respondent 4 has also, my lord, changed the, my lord, converted the land to Vastu, my lord. My lord, the petition thereafter, my lord, applied for sanction before the Makar municipality, my lord. The building plan sanctioned with the respondent 5, my lord, was sanctioned in 2016, my lord. And respondent 5 also
directed to complete the sanction, complete the construction within a particular time, within 3 years. Pursuant to that sanction building plan, my lord, my client started construction of land, building, my lord. During the construction, my lord, on 24th of June 2016, the respondent of 5 came to the building, my lord, came to the place and directed the petitioner to demolish the building without serving a notice, without in, my lord, the petitioner, my lord, and respondent of 5 also alleged encroachment of the land by the petitioner. But according to the petitioner, my lord, when he purchased the land, having submitted all documents, supported by, my lord, building plan issued by the
So your primary grievance is against the municipality.
my lord,
Your primary grievance is against the municipality.
no, my lord, the respondent of 4, my lord, you also can respondent of 5. Respondent of 5, my lord, came to the respondent of 5. My lord, yes, they came, you know, my lord, they came, my lord, they alleged. You also can see.
And the order you are challenging is also by the municipality.
No, district magistrate. My lord, this is the second round, my lord. First round, my lord, I came before this honorable court, and this honorable court was pleased to direct the petitioner to submit a objection written submission before the district magistrate, and with the direction upon him to consider. My lord, physical, my 2 points, my lord. First of all, I have all documents, my lord. And number 2, my lord, they have banked upon a physical survey which was made by them behind my back.
Where is the order impugned?
My lord, kindly see, my lord, impugned order is that, my lord, if you will also kindly come, page 99. This is dated, my lord, 31st of July 2019. The case record is put up before me for disposal. Sarath Pradhan, the petitioner, and concerned government officials are found present. Peruse the case record along with the report of BALL, Araro, Makura 1, written objection filed by the writ petitioner. Heard all, including the writ petitioner at length. It is established beyond doubt the demarcation of the school plot as done on 6th of March 2019. But 6th of March 2019, they have made alleged demarcation behind my back and without any notice.
It is recorded that you were present with your Amin at the time.
Hearing.
Demarcation.
They have alleged, your the writ petitioner along with the Amin was present at the time of demarcation was. That is not correct. I disputed, my lord. That is not correct. That is my whole point, my lord. They want to somehow demolish my building. The writ petitioner over the plot in question, the writ petitioner along with the Amin was present at the time of demarcation work. If I have enclosed, then the municipality would not have issued the sanction plan, my lord. Hence, it is presumed that the writ petitioner has also admitted to the fact of encroachment over the plot in question to accord LA case number 8485, and he has failed to produce any evidence contradicting the findings of the demarcation work carried out by the government officers in his presence. But let them show that I was present, the government, I was not present. No notice was given to me.
Then the state respond to this.
Kindly come to page 94 once. That is the
Yes.
that is the previous 11717 2016 writ petition.
Yes.
Now, my lord, kindly, why I am referring this writ petition, my lord, in that writ petition, we have filed an affidavit in opposition saying that in the year 1985, land acquisition proceedings was completed from, my lord, in that particular land. Now, they got the land in the year 2016 or somewhere
Now they have obtained conversion certificate, mutation certificate, then plan. Now they are coming. Land got vested already to the state and state has handed over in favor of the municipality. Thereafter, municipality has, since municipality is the requiring body, municipality has asked the DM to evict them. And this is the consequence of that demarcation. Now, Malad, kindly come to page 96.
Question, Mr. Dhar, is that whether the petitioner was present during the demarcation.
That's why, Malad, I'm referring page 96. Considering the claim and counterclaim as made by the advocate of the petitioner and the government officials, the undersigned is of the view that there is a need of further demarcation of the suit plot in presence of the petitioner and BLLRO Bakura 1, along with his concerned revenue inspector Amin and SRO 2 and TA DLLRO Bakura. Accordingly, the notices be issued to all the concerned parties, requesting them to remain present at the time of demarcation to be held on 6th March 12 noon. Then the Malad, as per this order, Malad, they were present.
No. No, I was not.
Order doesn't.
No
show
notice
this.
was given.
You have to show me the field report where the petitioner has signed.
And then Malad, I'll have to bring
Yes.
all the LCS of these proceedings.
Yes.
The field inquiry report where the petitioner has put his signature. That shows attendance. Not a recording in an order.
No, who is he?
Since this is challenged.
Who is he? After the date of, after the land got vested, he is claiming in the year from a deed of 2016.
You are not,
You
you say that only point some, a portion is 0.0096 acres.
Yes.
Vested. Your complaint is that the petitioner has encroached upon this land in constructing his building. Yes. So you have to show that the demarcation was done in.
Malad, I'll bring the LCR, Malad. I'll show.
LCR, particularly the field inquiry report, where the petitioner's attendance is recorded.
Madam, there is a threat of demolition any moment.
এতদিন হয়নি matter got dismissed for default,
Yes,
restored.
No, kindly have an instruction from your client.
2019.
Addressing the court, honorable court. Kindly have instruction.
That I know why my senior friend is going towards that. This order was passed on 31st July 2019.
Yes,
and we are in 2023.
Yes,
till date, nothing has happened.
Yes.
Now he is
Because the matter is being moved before.
Yes,
this
my
court.
lord.
It doesn't necessarily mean that it will not happen now.
Well,
Let there be a status quo.
give me 3 days time, I'll bring the LCR. I'll bring the LCR.
Doesn't that, my lord? Your Osaka status quo.
So it's an undertaking from your side that nothing will happen till the next date.
And then
I won't record anything. If it is from the bar, I'll accept.
yes,
Yes,
yes.
Shama. Affidavit of service. It is completed on behalf of the in challenging the order passed by the district magistrate Which district is this? Bakura. Bakura. On 31st July 2019, Learned Counsel for the petitioner submits that the demarcation referred to in the said order, on the basis of which it was decided that the petitioner had encroached upon a portion of government land, was held behind the back of the petitioner. No notice of such demarcation was served upon the petitioner, and the petitioner was not given an opportunity to remain present at the time of demarcation. Paragraph, the conviction of the petitioner is denied and disputed
Yes.
by, I know, denied and disputed by learned counsel for the respondents. Stop. Learned counsel seeks to submit a report in the form of affidavit. Yes? Or instructions.
But within 3 days, it won't be
Instructions.
possible.
Out of Kerala, learned counsel for the respondents seeks to take instructions in this matter.
No.
Please come back with the relevant documents.
No, as per
The
this
matter-
order sheet, they were present.
Maybe.
I'll bring the
Attested
LCR.
the
I'll
signature.
bring the
Or
LCR.
if the order sheet will not, if the order sheet records their presence, that is not sufficient.
And followed by a notice.
The petitioner's signature should have been taken.
Yes.
Paragraph, let the matter appear under the
আপনি dispute
same
করতে
heading
চাইলে ওই
on-
কোর্টে যান।
29th September.
Not a status quo in the meantime.
I think the.
Mala, kindly.
under-
Then, my lord, I'll take this point, my lord, if he disputes any court's observation or any administrative officer's observation, he is to go before that administrative authority or before that court that this recording is not correct because of this. He has not done so.
Since this is from the bar, I accept it. Please come.
Mala, if the
Next.
demolition then affected, mala, then I'll be. Huh?
59.
The whole will be there.
Sir, ARM তুলে কি
Mala, you are lost. Kindly status quo for a week only.
We need to.
Let them come within a week.
We need to have trust and faith on our learned counsel.
Mala, they are standing on the plot for demolition.
My lord, I'll have a word, my lord, I have already instructed.
Till
I'll-
the next date, there will be no demolition. That is what Mr. Dhar says.
Mala, can you record that, my
I
lord?
cannot, not possible.
But then will
Next.
status quo for a week.
Next matter.
Mala, status quo for 10 days a week, my lord.
স্যার বললাম, আমি বলে দিচ্ছি এক্ষুনি আপনার সামনে বাইরে বলে
শোনে মালের ব্যাপার not for court.
You have a very soft voice, Mr. Bas. Yes,
A settled law, 5 days, on 5
you are
days.
taking turns in taking adjournments. Earlier, first petitioner, then respondent.
I have not taken adjournment.
Yes,
I
of
have cited
course.
my judgment for your lordship consideration.
20th July petitioner's ground, it was adjourned.
Maybe one day, maybe. This is a settled law. This is not a transfer. I have cited a judgment for your lordship consideration. Division bench judgment settle the law for all time to come.
5th October. Mr. Bottabal, no further adjournment. Yes, Mr. Dey, where is Mr. Dey? I find Mr. Dey's name recorded, yes.
Yes, he must have a junior with him. He cannot appear alone.
Mr. Shorkar,
What is he? This much respect should be given to the court. State thinks they are privileged litigant.
Fifth October, please come back. On prayer of the state
Can it be given some
respondents.
precedent?
Yes,
Can give me some precedent? This is the law. I will not argue anything. I've cited a judgment for lordship consideration. They want to take instruction on that judgment. What I can do?
why don't you hand over an advance copy to them?
Given to him. Reported judgment. I have handed over also a copy to him.
In front of court দিয়েছি আমরা কোর্টে দিয়েছি কপিটা কোর্টেও রাখা আছে ফাইলে
Let the matter appear under the same heading on 5th October.
If possible, or some precedent maybe.
It will be
If
called.
possible.
It is being called. Huh?
Judges. He is here.
Madam, Mr. Desh, this is, Madam, Mr. Desh, presence is necessary, my lord. One matter is going on in court number 5, my lord.
Take your breath. Take your breath.
Sure.
On care of the state respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 5th October. Next. Oh, this is with 15.
With
They are together, yes. Mr. Shorkar, please be ready on the next occasion. If Mr. Dey is busy, you have to make your submission.
Yes, yes.
Oh, no, Nandini.
16.
My lord, petitioner, my lord. Lordship, I am for the private respondent, my lord.
This is the affidavit service, my lord.
Petitioner, you are appearing for the
I am
petitioner.
for petitioner. My lord, in this matter, private respondent, after encroaching the PWD road and constructed building, therefore I am not I am not able to go before my land. And my lord,
What is your prayer?
my lord, in the 11/123, Agra court also pass an order. I want to submit supplementary affidavit, my lord. Kindly see the order.
Ten two.
Yes.
Ten two.
10/4, 10/4.
The SDO to dispose of the 10-2.
This is a 10-4 application.
10/4 application.
Then 10-2 also finished. Lordship will direct the 10.
And also I have the order
10-4 can be.
10/4, 10/2.
10-4 has been disposed of.
Yes, my lord.
10-4.
10/2 and 10/4, both are disposed.
10-4
My
is
lord,
an
give me
appeal
liberty
practice.
to file supplementary affidavit. I will file the supplementary affidavit.
10-4 has been disposed of. Lordship will direct to fix the time limit. Well,
29 and 30 is my land. দিলে ভালো, যদি চাই তো দেবো।
What is your prayer?
My prayer to demolish the illegal construction.
10-4 has been disposed of. It will be automatically demolished. Why have you filed the writ petition?
But they are not taking any action, authority concerned, till pass the order by the Agra court. Therefore, copy আমার কাছে নেই, দিলাম order-টা।
Copy দেয়নি।
All completed, but not complete the process. I come before the court for that reason.
For implementation.
10-4 implement. Fix the time limit.
Yes, do you have anything to submit, sir?
No, my lord. My lord, in the writ petition, my lord, page 42, my lord.
Is the encroacher.
No, my lord, place demarcation may be,
After 10-4?
no, my lord. No, the copy has not been given, my lord.
Demarcation already.
You are aware that you filed an appeal?
No, my lord.
You are not aware that your client filed an appeal?
No instruction, no instruction, my.
No, not necessary. No further instruction is necessary. I'll pass an order.
15 February 2022. Demarcation must be by BLR.
15 February.
11 January 2023, which has been disposed of.
Yes, my lord.
10-4.
10/4.
So let it be complied with. Let it be implemented. Affidavit of service. The petitioner prays for implementation of the order passed by the District Magistrate Purbo Medinipur under section 10(4) of the West Bengal Highways Act 1964. By the Assistant Engineer, Tomlok Highway, subdivision, comma, being the fourth respondent herein. শুরুতে heard learned counsels for the parties forum. Affidavit পরে, affidavit service পরে heard learned counsels for the parties. Paragraph, it appears that the appeal preferred by the private respondent under section 10(4) of the Act of 1964 against the order passed by the subdivisional magistrate, comma, Egra, comma, Purbo Medinipur on 19th October 2022
Yes, my lord.
was disposed of by the district magistrate Purbo Medinipur by an order passed on 11th January 2023, directing the assistant engineer, comma, Tomluk Highway Subdivision, comma, PWD within bracket roads, bracket close directorate, to take necessary steps for removal of all encroachments over the government land in plot numbers 30 and 03, comma, jail number 117, comma, Mouja Nunhanda, 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 whatever, comma, police station Bhagwanpur.
Yes.
Within 30 days from the date of communication of the order under the provisions of under the provisions of the West Bengal Highways Act 1964 with the assistance of all concerned authorities. Stop. The said order has admittedly not been implemented till date. Paragraph, in view of the above, comma, the writ petition is disposed of, directing the fourth respondent to take necessary steps for implementation of the order passed by the district magistrate Purbo Medinipur on 11th January 2023 under section 10(4) of the Act of 1964 within 1 month.
Within 1 month, my lord, with the assistance of respondent number 7.
Within 1 month from the date of communication of this order. Paragraph, the seventh respondent is directed to render all possible assistance to the fourth respondent in implementation of the said order.
Wait, my lord.
Exactly.
Wait, my lord.
You can take this. Please give a copy of this. I'll keep
Yes.
it with the record.
Good.
What are the copy in the record?
No problem, sir.
Mention matters 298.
Sir, this is my application.
Service complete?
I was appealing for the respondents.
Served all respondent.
No, I want to file my position, my lord, in this case.
Why opposition? What is the matter about?
Matter about the
Unauthorized occupant, state officer has passed the order,
the order.
eviction order is there. Already an eviction order has been passed by the state officer. It's a public premises tenancy act, my lord. Already order is there.
Paragraph 5 and 6, your lordship kindly consider. My lord, may I read?
Didi? 1971 unauthorized of the Eviction of Unauthorized Occupants Act. 1971. সবসময় লাগবে একটা 62 একটা আছে, একটা 71 একটা আছে, দুটোরই শান্তকে এনে রেখেছি। Please give me a minute. Eviction of unauthorized occupants. আছে আমি জানি আছে। ওইখানে ওগুলোতে নেই তো, ওগুলোতে নেই।
ওই মনে করছে।
71 একটা 62 আছে, ওটা ওখানে দিয়ে দেবো। 62 ওটা ওয়েস্ট বেঙ্গল পাবলিক প্রেমিসেস। Yes.
Order is passed under section 5 of the Act, my lord, Act 1971.
Yes.
But without complying following the section 4(1) of the Act. My lord. Without notice, no so-called notice, nothing was issued. It is a mandatory provision, my lord, that's so-called notice to be served, and then the state officer will form an opinion, then an order to be passed under section 5(1) of the Act, my lord. Here in the case, my lord, moreover, my lord, petitioner was a licensee from 2010, my lord.
You have any document of license?
Yes, my lord, I have annexed the document at page.
Is page 17, my lord.
17, my lord.
Page 17, there is a temporary license given to them.
Temporary or?
Yes.
There is no mention which.
Yes, it is mentioned there. Temporary body is there.
But there is a provision under clause that was not, it's complied with.
Yes.
This was a temporary license issued in 2010.
Yes, my lord.
2010.
Period of?
It's a period of 5 years, my lord.
No, there is
Period of
no
5.
mention.
Where is it stated for a period of 5 years?
No, it is not in the agreement, my lord. It is under the rules, my lord.
It is
Regular
not
rules, it
agreement.
is under the rules.
It should be in the agreement.
They give the
also.
license, my lord, they know it about it. Each and
That is not
everybody.
sufficient. It should be stated in the agreement.
Yes. That's why, my lord, I want to file the entire documents. Here they have annexed the order of the state officer only, nothing else. Before that proceedings are there, we call them, they come, they appear, and all these things are
Yes,
there.
yes.
They have not
So will
annexed.
you come back with a report in the form of an affidavit annexing all the documents?
Yes, my lord, yes.
Yes, will you do that?
Yes, I'll do that.
Not a full-fledged affidavit, come back with a report in the form of an affidavit.
In the form of affidavit, with the report. not
My
the
lord, in
paragraph.
the meantime,
Only some documents
protection
have
may
to
be
be.
given, my lord. In the meantime,
Where is the eviction notice? That protection will be given?
page 21, my lord.
Of course, they have not vacated the premises, so we have given a notice, my lord, by the state officer.
When was this issued, this notice?
Issue date is not mentioned.
Yeah. How can be?
Nothing, my lord, it is a
Served on 20. Served on 10th.
Region 23 of course.
served it on 10th, my lord.
Yes.
This was served, my lord, on 10th September. But order itself.
In that case, let there be no coercive action till the next date.
Till the next date. No, yes. I need 4 weeks time, Lord. I will. The Lord say fix for hearing.
4 weeks takes us after the vacation, isn't it?
My lord.
So will you come back after vacation?
After.
Till the next date, no coercive steps.
After vacation.
Till that date only, my lord, only.
Yes. The petitioner challenges the order of eviction passed by the estate officer,
Yes, state of.
passed by the estate officer, Eastern Railway / Malda Town on, the date is not there. Malda Town, directing the petitioner to
Date আছে
vacate the premises in question within 30 days from the date of publication of the order. Stop. The order is undated. Undated. Stop. Paragraph. Learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter, annexing relevant documents.
Yes.
Paragraph. Let the matter appear under the same heading on 30th November.
30th.
Paragraph. No coercive steps be taken against the petitioner by the respondents in respect of the plot in question till the adjourned date. Service.
Next copy service করতে next
সব করেছি
একটা কাউকে পাঠান না বইটা পড়ে।
কপি তো আমরা পাইনি কি করে বের করব
এলে পাঠান।
এটা দিয়ে তো এটা দিয়ে দাও But this is
299.
also identical matter, but affidavit.
The same order be passed?
Well, in this matter, my lord, we have not been served a copy as yet. I don't know.
No,
whether
I
he
have served.
whether he has served the department, the Ministry of Law. We have not received. We received only one. If you can serve a two copies, my lord, in the
I
two
will serve-
matters,
Serve an extra copy.
Today are, আছে কপি আছে?
next matter, next two matters. Every service file করেছো?
এই তো affidavit sir. দুবার করে রাজু
Where is your affidavit of service?
Yes. রাজু
21013.
2.9. 299 কোনটা? রাজু তো দিয়েছি। রাজু তো দিয়েছি।
299.
হবে না, আমি next day 30 number করেছি 30 নম্বর
Not served?
আসমুল আসমুল
Police.
আসমুল
যা যে পকেটে সব হাতে কপি দিয়ে দিচ্ছি এখন
একটা 21
হ্যাঁ, ওটাও
2013
দিচ্ছি কপি দিচ্ছি
একটা
Where is
পেয়েছি
the track report? Where is the track report? Why do you give incomplete documents?
hand service
হ্যান্ড সার্ভিস
office receipt money.
anyway they have served a copy right now Lord.
What number?
Huh? Assuming.
আসমুল
Served at the article receipt room.
মানে
Please give an.
One copy I have.
So let the same order be passed
Same one.
because it's the same one,
Yes.
order I find.
But the date should be fixed, my lord, the date particularly, so the matter appear in the list, my lord.
38,
On
the same
30th.
thing, same.
Yes,
And it will be state, I mean, no coercive action till the next day.
yes, till the next.
Same order.
Next matter আছে আরো?
Next matter. We undated the same.
Next one is this.
Same. Have you received copy in the next one?
No, no.
I'm the.
Same.
Yes.
The order is also the same? Undated order?
Yes, ma'am. ठीक है.
All
Yes,
same.
Pasha same order. Same date also, 30th.
Same date. हाँ चल रहा है. नाम तो दिए थे. You are appealing, sir. अच्छा.
300 you are appearing?
Just 5 to 7 minutes ago, I have received.
So I'm giving you a copy to him.
You are
Otherwise,
not appearing in 300.
and till now I have not been served. So
300 I have been instructed to appear, but just 5 to 7 minutes ago, I have received.
only order you pass. 30th November.
I have passed orders in the earlier two matters which are similar. That learned counsel wants to come back with a report in the form of affidavit. Primary grievance is that they were not served with notice.
Service.
So please come back with the documents. Let there be no coercive action till the next date.
There is an interim order is there. Let kindly take it on the tomorrow, my lord.
Sir,
So that I
tomorrow-
can go through them.
Similar matters, come back on
You
the
file a
next
position.
date.
My lord, I think. my
Till
lord,
the next date, I have granted an order.
Just I have shown, my lord, one page. My lord, probably, my lord, there is an provision of appeal against the order of the estate officer. So, my lord, how this matter directly can be filed under the writ jurisdiction?
Maintainability question is also there.
Is
Is
there.
also there.
So, there is an alternative.
Principles of natural justice, you have to show that you were served, they were served, they were given a hearing.
So, my lord, specific solution for appeal is there when.
What about violation of natural justice? When they are not heard, the writ court can entertain.
So,
The petitioner is claiming violation of natural justice.
my lord, kindly consider if, my lord, authority passed any order without having any jurisdiction or without giving an opportunity of hearing anything. That all that can be raised before the appellate authority.
Not at all.
No.
The writ court can
Before the
entertain.
appellate authority, my lord.
The
How
writ court
about
can
the
entertain.
writ jurisdiction. So, my lord, I don't know.
This
the
is
whether
settled
there
law,
is
Mr.
any-
Ghosh.
any, my lord, the opportunity of hearing was there. Or, my lord.
Please come back
prior
with
to-
documents on the next date.
prior to, my lord, only they have annexed them.
Yeah,
So, my lord,
that
kindly-
you have.
kindly, my lord, give me 1 day time so that I can go through the petition. And my lord, I can take the instruction whether, my lord, the opportunity of hearing or everything was natural justice, provision of natural justice was complied or not.
Instruction will not suffice. You have to file documents to show that the petitioner
lord,
was
in
served
that-
notice.
That case, my lord, kindly consider only one thing, that the specific provision of appeal is there.
I repeat, even if there is a specific provision of appeal, the writ court can entertain when there is violation of natural justice. Without hearing the petitioner, if an order has been passed, then that is clear violation of natural justice.
That is
The
they
writ
say, that
court
is what they
can
say.
intervene.
Whether it is without hearing. or
Come
not,
back with documents, Mr. Ghosh, that's what I'm saying.
That is his statement.
Yes, yes.
Whether really that was happened or not.
And if other documents are
That
counsel
may
is
be
not
one-
willing to show any
But he
documents.
was not so long back. He was not appear, that may be. I don't know, my lord.
So I am giving you an opportunity till the next date. And it will be no coercive action till the
And my
next
lord,
date.
in case of several judgment is there, my lord, in our court also, that in case of any commercial contract with the railway, as soon as, my lord, that contract is not renewed, or, my lord, that has
You are on
expired,
merits.
my lord, he has no authority to occupy the railway land.
You are on merits of the case.
My
I am
lord,
only
kindly
on
consider,
service of
kindly
notice.
consider one thing. Let them produce a valid license. Let them produce, my
I
lord.
am not on merits at all. Prima facie, please produce a document to show that you have heard them
So,
before
my lord,
passing an
when
order.
your lawsuit is pleased to, my lord.
30th November. Next matter.
30th.
Briefly,
Hey, yours.
101. 301, my lord, I am appealing for the petition. Yes. My lord, this is my affidavit service. My lord, here I am challenging
Service, have you served the private respondents? also?
private respondent, my lord, I served insufficient address, came back. And my lord, that
Complete
endorsement,
service.
my lord, that is envelope, my lord, all entire, my lord, turned down and then packed. My lord, I am challenging here the
There is only
notice.
one service which is Insufficient address. Where is the other service?
my lord,
There are two.
as
private respondents.
insufficient address, yesterday I served, my lord, another notice,
So
private
complete
respondent.
service and come back.
My lord, next week, my lord, any date, my lord, because yesterday already, my lord, I served. Yesterday already served two private respondent, my lord, for this reason. My lord, here I am challenging.
I first mentioned the matter and got a place in the list.
My lord, after that, this
Then
was,
you are
this
thinking of
was written.
service.
My lord, after that, this was
Since
written.
service upon the private respondents is not complete, comma, let the matter stand over till 12th October.
My lord, in the prayer I have seen, they prayed for quashing of the proceedings issued by the revenue officer, block land reform officer, 2 hours.
That's against dead person. All are dead, my lord, against them, the proceeding has been initiated.
Under the Land Reforms Act.
Under land
Yes,
reforms,
yes.
kindly say for a moment, I also annex a death certificate. Page 60, my lord, if your lordship, kindly see for a moment.
Land Reforms Act, this court cannot deal.
Yes,
My lord,
deeply obliged, my lord.
this was, my lord, I am challenging the natural violation of natural justice, specific averments.
Dismiss.
My lord, in kindly see,
Where is violation of natural
my lord,
justice?
kindly see page 60 for a moment. Page 60, my lord, Badi Nam Konoklata Nandi. Page 60.
This is also violation of natural justice.
My lord, against dead person, can a proceeding shall be initiated?
If you cannot, you have to approach the appropriate authority.
My lord, in earlier occasion, your lordship decided the issue, the point of natural justice. For that reason, I filed before your lordship.
Show me the earlier order.
Etu din to. And my lord, all the my lord parties are dead. And I did not file any application before the revenue officer. And revenue officer initiate the proceedings. I am not file any application before the revenue officer.
What was your ground in the earlier writ petition?
My lord, in earlier occasion, violation of natural justice. Order passed by the BLLRO.
Yes, what does
Proceedings.
violation of natural justice indicate in this writ petition? You are not given an opportunity.
Yes, my
of
lord,
hearing.
page 60 kindly say for a moment.
Here it was, this is not connected to this at all. Here you are not given an opportunity of hearing. That is violation.
Here
of
also, my
natural
lord, I am not given any opportunity. My lord, proceeding has been started. My lord, I am not filing any application before the revenue of inspector. I am not filing any. If your lordship kindly stay for a moment, page 60. Page 60.
Yes.
My lord's name, Badi Nam Konoklata Nandi. Konoklata Nandi is my mother. My lord, she already died, my lord, in the year, my lord, 31st July 2022. I annexed the death certificate, page 63. I annexed. My lord, Bibadi Soponde, Ashoka Mondol, who also, my lord, died in the year, my lord, 15/8/2022. Asalota Mondol already died in the year 2018. And Monorama Kundu, who is, my lord, aged about 90 years.
My lord,
My
whether
mother
petition is
is
maintainable.
Nandi.
Petition
My
is not
mother is
maintainable.
Nandi. My lord, I annex the death certificate, page 63 for a moment. Page 63, the death certificate of my mother. And my mother did not, that is the, my lord, kindly see the date of death, 1/8/2022, date of death. Have your lordship got? My lord, the date of death is.
Did you inform the death to the authority?
Already, my lord, I informed. My lord, they did nothing. And they, my lord,
prior to issuance of this notice, did you inform?
My lord, after receiving of this notice, I already, my lord, give elaborate representation, annexing all the documents, and kindly see 60, my lord, case tarikh, 20/2/2023. Case tarikh, page 60.
Yes.
20/2/2023. My lord, how my mother who died in the year, my lord, 31st July 2022.
How will the authority know about the death unless you inform the authority?
My lord, already I informed. They initiated and they corrected the record of rights. My lord, for that reason, I am filing this
Where is the
application.
document?
Documents, that is page.
This
My
is a
lord,
notice issued against dead persons.
yes.
In that occasion, my lord, he has not a right to come before your lordship. As because, my lord, West Bengal Land Reforms Act, that is a prescribed, that is the, my lord, that is a 2R, according to 2R, that will be, after that, my lord, 6 and 8, they have not any right to come before your lordship.
The petitioners were not served any notice. That is
Whatever may be that, he must go there.
No, violation of natural justice.
My lord, that is violation.
Can it
Then
be?
everybody will come and say whether, my lord, how your lordship knows that,
Document where you have served the petitioners, it will go.
My lord, this is not the forum to show before your lordship.
This is the forum. Several
Well, that
judgments
is-
are there. Several judgments are there.
That is, my
Violation
lord,
of natural justice, then the writ court will intervene. Please show me a document that you have served the petitioners before the hearing.
but
You
then
have
ever to
served
বলো তো
dead
তোমার কি
persons.
মামলা?
আমি বলে দিলাম তো, ওই তো পেজ 60 একবার দেখুন নোটিশটা, পেজ 60। এই এটা সবাই মারা গেছে, সব ডেড।
Petitioner is Tarapada Nandi.
The son of the Konoklata Nandi.
Then my lord, your lordship will come. My lord, he made the petition, my lord, in that way. That the grandfather of the petition, namely Govinda Kundu, was the original owner of the property, who got the entire property by way of legal inheritance. After his death, my lord, his wife, Ranibala Kundu, and her 4 daughters, namely Ashok Mundal and others, was there, my lord. That after the death of wife Govinda Kundu, namely Ranibala Kundu, and all of the daughters recorded their name in the revisional record of right. The name of the father of the respondent 8 and 9 was the Borgadar under the grandfather of the petitioner. That the father of the respondent number 8, 9, and 20 died 20 years back, that is in the year, and from time to time no Borgadar was cultivated the lands of the petitioner, and no one gave any share of the crops of the respondent number 8 and 9. Also not recorded their names in the recorded rights. That the mother of the petitioner, my lord, Ato, Oloka Mundal died on Ato, Asalota Mundal died in Gujarat Ato, only one legal year. Ranibala Kundu is alive and aged about more than less than 80 years old. That all on a sudden one notice was based upon Ato, 18 and 21D of the Ato, 14 of the West Bengal Land Reforms Act, received by the petitioner, in which the dead person name became plaintiff and the notice was issued against the dead person.
I think you don't need to read any further because you have attended the hearing. Please come to page 66.
My lord, for a moment. My
You
lord,
have
for a
admitted attending the hearing.
My lord, hearing, my lord, on that day, on 16/3/2023, I met the revenue inspector, and my lord, revenue inspector, as I am not the petitioner of that, my
The
lord,
hearing
proceedings.
was made in your presence. That is your submission.
My lord,
That
no
is-
hearing took place. If your lordship, my lord, kindly direct my learned friend that produce the record. Kindly, my lord, no hearing. My lord, my lord, only met the revenue inspector for information and for giving the representation. And representation I made.
Your letter, please come to page 66.
Yes, page 66. Yes, I made representation before the
You were
authority.
present on the date of hearing which was held on such and such, but till date I did not.
No
receive result.
order has been initiated. No order has
So
been.
hearing
My lord,
was held in your presence. You have not received a
my
copy
lord,
of the order. So this
only,
court
my lord,
will not
submit
have
the copy. My lord,
jurisdiction.
let them, my lord, learned friend, my lord, direction may be given
Two
to produce-
options.
to produce the copy of the order. To produce the copy
Two
of the order.
options. This will be dismissed because this is under the Land Reforms Act. This court cannot consider no violation of natural justice. You have attended the hearing. Or you can withdraw and approach the appropriate forum.
My lord, kindly direction may be given to produce the copy of the order. My lord, as
give
per
you-
my
This
representation.
court cannot give such direction in this matter at all.
My lord, that notice issued, my lord, I received, not my name.
I think I've made myself clear. I give you two options. You can either withdraw and approach the appropriate forum, or
My lord,
have to dismiss on
my lord,
only on this ground.
My lord, how I approach
Not
before,
necessary.
no notice
So it
has
will
been
dismiss.
served to me. My lord, all the dead person
I've
notice has been
attended the
served.
My
My lord, on behalf, my lord, that was not, they did not allow me.
on this ground. Affidavit of service.
But they did not allow me at all at the time of hearing. Because I am not in the party in the proceedings.
You have attended the hearing, so there is no violation. It
My
has to
lord,
be dismissed on
my
this
lord,
ground.
kindly,
itself.
kindly produce the attendance register.
Not at
My
all.
lord, kindly.
It is yours. Please do not spend time like this, please. You have admitted in your letter
My lord,
that
if
you have
your-
attended
my
the
lord,
hearing.
if your lordship, my lord, kindly direct them to produce the copy of the order. Everything will be, my lord,
Repetition
disclosed
will not
before your
really help
lordship.
you.
And my lord, attendance
I
register.
say repetition will not help you. You have stated this, I have refused. It will either be dismissed or you can withdraw and approach the appropriate forum. You don't want to withdraw, so it will be dismissed.
But without copy of the order, my lord, I did not approach anywhere. But no order has been served to me at all.
Representation considered.
But then, my lord, consider my representation, my lord, then
The
my purpose
petition-
will be served.
Praise for quashing the proceedings, being case number BW/2023/0118/10.
My lord, then, my lord, I am
Dated
withdrawing, my lord, to
20th
my application.
February 2023, pending before the revenue officer, comma, West Bengal Land Reforms Office, comma, Jaipur, comma, Bankura.
But then, my lord, I am withdrawing my
Under-
application.
Yes,
I am withdrawing my application, my lord, with liberty to, my lord, to-
after spending so much time.
My lord, at least,
Under
my lord, the
the-
representation. will be considered, my lord.
Under the West Bengal Land Reforms Act 1955. I am not insisting on withdrawing. I will just pass an order.
My lord, then, my lord, all the doors, my lord, will be closed, my lord, if your lordship pass that is the order, my lord.
I record that this will not preclude you from taking necessary steps before the appropriate forum.
And then, my lord, I am withdrawing, my lord.
Paragraph learned counsel for the petitioner. This is purely under the Land Reforms Act. Can't help. Learned
But
counsel,
only rejection, my lord,
counsel for the petitioner seeks to
order can be, my lord,
withdraw the
delivered.
writ petition and approach the appropriate forum for redressal of the petitioner's grievance. Apostrophe S. Paragraph in view of the above. Oh, এটার আগে একটা লাইন করুন, the matter pertains to the West Bengal Land Reforms Act 1955. আচ্ছা দরকার নেই, একবার বলেছি, ঠিক আছে, ঠিক আছে। A paragraph in view of the above, the writ petition being WP such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, there shall however be no order as to costs as in certified.
Please have this করা হলো।
এটা ফেরত দিন আর এফিডেভিট অফ সার্ভিস দিন।
I appeal for the respondent number 5 and 6.
But I first does not like this objection to the.
It is appearing for the petitioner.
Lordship, may I please? Lordship,
It is under challenge, so we have to hear out that.
Order has been passed under a specified act.
What is challenged in the writ petition?
That order. This is the order which has been passed under a specified act by the PWC controller. Section 2R.
26th April order. Where is the order at page?
Page 52 onwards it starts.
Page?
52. You can also see, you can also see 51. Under section 5 of the Regulation Act 2001.
Not necessary. That is not, that's settled principle. This is the LRTT Act you are showing. That is settled law.
So he has to go.
may I please, Your Honor, no? The Lordship,
LRTT he has to go under.
This order is passed by whom?
by Deputy Controller, Calcutta Tika Tendency.
Under a specified act.
So how does this court have jurisdiction?
Lordship, I'm coming. Lordship, once my learned friend has opened this part, I'm coming to page 53.
Yes.
In the order itself, your Lordship can see para 1, RF number 13/900. In this case, in subpara A, it has been written further and unregistered deed of the agreement executed on 9/9/1980 between so and so.
This has been produced and pursuant to this deed, tika tenancy has been declared. Now, Lordship, that particular document is annexed. The certified copy of that document is annexed.
You are on merits of the writ petition, sir.
Lordship, I am coming. Lordship, this document is already under challenge, coming to be a forged document.
So you have to wait for the challenge to be met.
Yes, challenge has already been made and
So
the
the-
matter is pending before this Honorable High Court.
So the writ petition is premature.
No, Lordship, because the order has been passed, rightly or wrongly, an order has been passed. The appeal period is there. This is an appealable order before the land tribunal. So, and on the
And
base,
this court doesn't have jurisdiction to deal with matters under the tika.
Lordship, your Lordship has got ample jurisdiction to transfer the matter under Section 9 of West Bengal Land Reforms and Tenancy Tribunal Act.
Cannot, no.
Lordship, if-
appear for respondent number 5 and 6. Milord, in connection with the self-same cause of action, they have filed an writ application before my Lord Justice Joyson Gupta.
No, not on the,
Application, Milord, this is the order. There they have stated, being aggrieved, the petitioners have already preferred an appeal against such order before the appropriate authority. That means selectivity. But I have not received any copy, Milord, and no intimation has been served upon me. This is the first point of submission. And second point of submission, Milord, they have preferred this writ application on the basis that an illegal document has been considered by the Honorable Tika Controller. Now, Milord, they have lodged FIR before the Uldodanga PS. Now, Milord, Uldodanga PS has submitted FRT.
Submitted FRT.
no, no, Lordship,
all the
I have
things
not
that I have
filed.
annexed
It has been filed by the agent of,
Milord, can you see this order once?
Now, this court is not concerned. with
Lordship,
that
Lordship, may I,
The Tika Tenancy Act.
Lordship, absolutely,
The
but
order
it has to be, it is the point to be verified.
Dismiss the matter on. this
No,
basis.
Lordship, in that case, let me, Lordship.
Milord, they
Lordship,
have not
first of all,
before your Lordship with clean hands.
Absolutely.
Milord, they have
Lordship,
Prima facie it
the
appears-
thing is, this case is under challenge, under whether the client is suffering, whether the action is violative of Article 300A or not. This is my point. Now, basing on a false document without verifying its original, if an authority,
You have already preferred an appeal.
no, this is the application has been made.
It's recorded in the order of the court.
Lordship, that is, this application has been made.
LRTD has the jurisdiction, Milord.
I am, Lordship, no, Lordship, I am considering that there is a gross violation of Article 300A. Let that point be fulfilled at first.
Not necessary in this court at all.
Lordship, because,
this is
no,
the
Lordship,
FRT,
because
Milord.
Necessary.
question of FRT,
Two options. You can either withdraw or have to.
no,
dismiss on the
Lordship,
leniency point.
then Lordship has ample jurisdiction to transfer this matter itself to Land Tribunal under Section 9 of West Bengal Land Reforms and Tenancy Tribunal Act.
Already filed an appeal. It is recorded in this.
No, not appeal, Lordship. This is this application.
An appeal and an application.
No appeal has been preferred. Appropriate application has been preferred.
Aggrieved, the petitioners have already filed an appeal against such order before the appropriate.
That is
authority.
this authority, Lordship. I have filed this application.
Sir, this doesn't-
Appeal
doesn't
lies before
indicate so.
LRTD.
Eh,
Appeal lies
Then
before
Lordship
LRTD.
has ample jurisdiction to transfer this application
Sorry,
as under Section 9.
third learned counsel.
Lordship, may I please,
An order passed by the
Lordship,
deputy controller.
then Lordship, I'm withdrawing the present application and intending to file afresh before appellate authorities.
Cannot deal with it, and you have not come with clean hands. I wish to, in fact, dismiss and not allow you to withdraw.
Lordship, but one point has to be considered that this application has been filed. Nah, this order has been passed. Lordship, peruse this point. Order has been passed basing on a Xerox copy.
Immaterial in this court, it's irrelevant.
Lordship,
Irrelevant.
Milord, FRT has been submitted, Milord, kindly.
FRT, question of FRT, that FRT is challengeable. And this application is,
Challenge that FRT.
Lordship, I have not filed the complaint. So question of challenging FRT by me doesn't arise. It has been filed by one of the agent of the private respondent.
Mr. Ganguly, nothing further is required to be submitted. It will be dismissed on twofold grounds. Firstly, because this court doesn't have jurisdiction. Secondly, I would like to record that the petitioner has not come before this court with clean hands.
Then Lordship, let it be withdrawn and sent back to Land Tribunal.
After I've expressed my mind. Ki bolna?
Lordship, I'm not pressing the application.
Huh?
In that case.
An order passed by the Deputy Controller, Kolkata Thika Tenancy Deputy Controller, Kolkata on 26th April 2023 is assailed in the writ petition. The writ petition is not maintainable on twofold grounds, : firstly, since this court has no jurisdiction to deal with matters under the West Bengal Thika Tenancy Act. Stop. Secondly, it appears from an order passed by a coordinate bench on 4th September 2023 in WPA 21268 of 2023 that the writ petitioners have preferred an appeal against the order under challenge in the present writ petition before the appropriate authority, such fact being deliberately suppressed by the petitioners in the present writ petition. Stop. The writ petitioners have not come before this court with clean hands and are therefore not entitled to any relief in this court. Paragraph in view of the above, the writ petition being WPA such and such is dismissed.
Lordship, these
There
application
shall
has,
however be no order as to costs as in certified.
Lordship, this application has been filed on 1st September. That has been recorded as an appeal, not before the appellate authority.
It has not been recorded as, it cannot be recorded as an appeal.
No, Lordship,
Next
this application has been filed. The
So,
order has been
I've
passed by
passed an
His
order,
Lordship
sir.
Justice Sengupta on 4th
I have
September.
already passed an order. Next matter.
Lordship.
303. And I'm for the stay.
That's something, my lord, I am appealing for the petition.
It is under the specified act, madam. My preliminary objection.
Could you all specify that matter?
My lord, here, my lord, the petitioner number one purchased the plot in the year 1978.
What are you
From that-
challenging?
My lord, here, page 22, my lord, on all of a sudden, the petitioner, my lord, came to know that their plot has become Khotiar number 1. And after that, page 22, my lord, from 1978, the plot was purchased by the petitioner number 1, and from 78, my lord, they are residing to there, and my lord, they enjoyed the property. On all of a sudden,
Court
page
cannot
20
decide, my lord.
my lord, Khotiar number 1. My lord, I made right to information, page 23, seeking information about the BR case and by which way this land was converted as a Khotiar number 1, page 23. If your lordship
Which
kindly
order
see,
are you challenging?
my lord, page 24, my lord, I am page 25, my
This
representation.
is my,
Page
this is my
24,
reached
What
order.
are you
RTI.
challenging?
my lord, no order has been
No.
passed. I am not served any copy of the notice, nothing. My own land that was enjoyed from 1978, that was become Khotiar number 1. For that reason, I made right to information application, and they replied, page 24, if your lordship kindly see for a moment.
Then again, she wrote.
In reply, my lord, kindly see for a moment. In reply to your letter such and such, received by these office dated such and such, this is to inform you that the information you sought for regarding BR case in connection with LR plot bearing number such and such is not readily available at present.
What
This
can
is
be
under
done?
the Land Reforms Act.
Yes, my lord.
My lord, then I
Grateful to
made
Lord.
representation before the authority. My
This is under
representation-
the Land Reforms Act. Yes, ma'am.
my lord, without serving any notice, my lord, they converted my land.
They have
Whether,
closed.
my lord, I am
Approach the
enjoyed my
appropriate authority,
property
ma'am.
with permission, with construction 1978. My lord, nothing has been served to me. I made elaborate.
Approach the appropriate authority for
Grateful
a
to
correction
My
of record of
my
rights.
representation should be
You
considered
are
after
asking for correction of record of rights.
They
isn't
had
it?
come to this
That
honorable
is
court
what
within 2
I-
days.
was not correct, should not be corrected by
your
the
lordship-
if your lordship kindly see the act, that is 2012 act. When that was become Khotiar number 1, that was vested by the state of West
She can
Bengal.
ventilate
And
it before the tribunal.
without informing me that was vested, my lord, if your lordship kindly see
Read
the
court
section.
can act.
My lord,
Land Reforms Challenge
under the Estates and Forfeiters Act 2012, kindly see the act. This act came into force in the year 2012. Did it? And if your lordship kindly say the section 3, but when that was become Khutian number 1, where no one enjoyed the property, no one claimed the property, then my lord state government and is the owner by way of my lord and described as
This
Khutian
land is
number 1.
this land is already vested. Only unclaimed properties can be vested, you mean to say, not properties
By a
owned by
proceeding,
people?
this land is vested. I purchased my plot and from that I enjoying my plot over construction over there. I enjoying, my lord, I am still in
Sorry, this
possession.
court cannot help
Yes,
you.
my
with
lord.
this
My lord,
approach.
that way, my lord, representation should be considered. My lord, upon giving
not at all.
hearing.
After making, within 2 days, they have come before the honorable court after making
No,
the
my lord,
representation.
I
She made representation on 30th August and she filed.
not giving, my lord, intimate.
She made the representation on 30th of August and
And
repetition filed on 4th September, within 3 days.
They replied me that there is nowhere about the BR case. My lord, I am specifically.
This is not the forum.
You submitted your representation on 30th August.
30th of August and your lordship kindly
And
sees.
immediately thereafter, you came to the
My
court.
lord,
4th September.
Second September.
So you have filed
When
repetition on
did you
4th
file the
September. On
Well,
4th
after
September.
Immediately after that.
Immediately.
This is not the
Immediately.
only representation before the authority.
My lord, prior that I made right
You expect
information.
the authority to decide your representation on the same day that they receive it?
Yes, I'm
No,
grateful to
that
your
is not,
lordship.
my lord, I am to take proper steps.
Have you given sufficient time to the authority? You have not.
Then my lord, kindly, my lord, direction.
This is
may be
not
given
in any
for
law.
that my representation.
This matter cannot be dealt with by this court.
And if your lordship kindly sees the letter,
My
they
lord,
want
this
the
is
9
not
name to be
With
muted.
we are case proceeding which cannot be dealt
But
with
I
by
am
this
not
court.
in my land reforms act. I am come under 2012 act.
In the
How is the
letter,
2012 act related to this?
madam,
My lord, they declared my land as a Khutian number 1. Khutian number 1 is the vested land of the state government. That was no notice has been served, nothing has been served. All of a sudden they declared as a Khutian number 1.
Approach the concern,
Yes,
the appropriate authority.
My lord, I approach.
Yes, madam, you want to say
my lord, if your lordship kindly takes the page 25 in the letter to the authorities, they have only prayed to mutate the name of his mother. The petitioner number 2 has only prayed to mutate the name of his mother. There is no whisper about the proceeding. Your lordship kindly sees.
My lord, in
Your lordship kindly sees. I paid all the statutory taxes before the administrative department and also I'm in possession, but till dates.
Your prayer is for mutation.
My lord.
that should be,
Yes.
if they consider
Contradictory, all contradictory prayers.
My lord,
All
they
contradictory
declared
prayers.
Petitioner prays
In
for.
the prayer, they have prayed for quashing, and in the letter, they have prayed for mutation.
Mutation of her mother's name in respect of the plot in question. Paragraph, the matter pertains to the West Bengal Land Reforms Act, 1955. Paragraph. শুরুতে affidavit service. Do you have the Tenancy Tribunal Act of reference sections? Paragraph, in view of the provision laid down under section 8, madam. 2(1) and 8. 6 and 8 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997, comma. This court has no jurisdiction to deal with matters pertaining to the West Bengal Land Reforms Act, which is a specified act under section 2(r) of the Act of 1997. Paragraph, in view of the above, comma, the writ petition being WPA such and such is dismissed as not maintainable. Paragraph, however, dismissal of the writ petition shall not preclude the petitioner from taking necessary, from approaching the appropriate forum for redressal of their petitioners, for redressal of their grievance.
Deeply obliged.
Paragraph, there shall however be no redress to costs. Origin certified website. Void of Hiroti.
Grateful to.
Yeah.
But I am for the petitioner. এটাই কি 5? And the improved order is at page 19.
Mr. Sen is the arrest.
Minor.
আরেকটা কপি করিস নি কেন?
Is it compliant?
No, my lord. My lord, would your lordship be kind enough, my lord, to go through this, my lord? So far, the serial number 9, 10, and 11, though this is my instruction, I think, my lord, this should be placed before your lordship. আমি দিচ্ছি এটা মাত্র দুটো কপি আছে, আমি পরে তোমায় দিয়ে দিচ্ছি. And my lord, kindly have a look at the, my lord, the annex document also. My lord, so far this route is concerned, my lord, admittedly, it's a my lord, notified route and the strength is fixed. Now, my learned friend's contention all along was that, petitioner's contention all along was that. My lord, kindly do not go through this. My lord, kindly, my lord, just so far the facts are
You
concerned.
cannot go into the facts.
No, I am not on that. I am not on that. I'm not on that. My lord's order was to comply my lord's order along with in terms of the compliance of the earlier order.
Yes.
Now, in the earlier order, my lord, there was a specifically mentioned that there was one vacancy at one point of time. And so his application should be considered in terms of the said, my lord, the vacancy. I think, my lord, my lord's order was, my lord, that because the vacancy actual that's reflected in the earlier order, in earlier writ petition. And my lord's order is that should be considered, whatever the direction. Now, my lord, here, my lord, it appears that my lord, petitioner was asked to appear before the RTA board after my lord's order. Now, my lord, lordship, kindly, my lord, come to, my lord, paragraph number 10. So for the instruction, lordship, paragraph 10. The petitioner appeared before the RTA board meeting dated 10th July 2023, and she was duly heard. The RTA board discussed the matter and decided to give the preference of offer letter to the petitioner when vacancy will arise in route number 71. The decision of the RTA board meeting dated 10 July 23 was communicated to her by memo number such and such dated 10th of August 2023. At this, may I tell, at this juncture, it appears that the contempt petition has been filed. Now, the matter was again taken up by the RTA board. That since it's a contempt petition, let us discuss the matter again, that whether the order has been complied with or not. In their suo motu, they have taken that. Then, lordship, kindly come to paragraph 11, lordship. In view of the initiation of contempt of court proceeding bearing 979 of 2023, filed in Honorable High Court, Calcutta, the RTA board in its meeting dated 8th of September 23 has decided to look into the matter afresh. And for that, a fresh resolution or decision will be taken by the RTA board in this matter in the next board meeting, when subject to leave of the Honorable High Court, Calcutta, a fresh decision will be taken by the board with regard to the direction in the order dated 31st of March 2023, passed by the Honorable High Court. Now, my lord, kindly come to the, my lord, the resolution. My lord, kindly the annexed document. My lord, at the bottom, its caption is resolution. Left-hand side, lordship, resolution at the bottom. In view of the initiation of contempt of court proceeding bearing number 979 of 2023, filed in Honorable High Court, Calcutta by Mrs. Subhashi, the RTA board has decided to look into the matter afresh. For that, a fresh resolution or decision will be taken by the RTA board in the matter of WPA such and such in the next board meeting, when subject to leave of the Honorable High Court, Calcutta, a fresh decision will be taken by the board with regard to the direction contained in the order dated such and such. The Secretary RTA Kolkata is requested to communicate this to the learned state advocate with a request to make a prayer before the court for allowing the RTA board to take a fresh decision. Now, this is today my lord, my humble submission
that this is the prayer of the RTA board to make it before your lordship, that kindly give some time, my lord, let them take a fresh decision, whatever decision they have taken, pursuant to my lord's order, my lord, kindly, my lord, allow this.
No scope for taking a fresh decision by the RTA board at all. No decision is required by RTA board. The order has to be implemented, that's all, nothing else.
My lord, the order,
Since you have not preferred an appeal against
no,
the
no,
order.
order is to be, no, fresh decision means that my lord was kind enough to, my lord, direct the
You have to
RTA board
the
to
petitioner
direct the
24th vacancy. That's all,
My
nothing else.
lord, so far the early, my lord, when my learned friend's client went there on my lord, that 22nd July or something, a decision was taken.
Also not required. There was no direction to call the petitioner at all.
Yes, my lord, but my lord, he has taken that point.
Yes,
But
page 14, my lord, kindly.
But
come to
my lord-
paragraph 22,
but
that
my-
there was no scope for any.
in terms of the, in terms of the provisions of the statute, my lord, the hearing is necessary to the applicant. Otherwise, that may be a point. Lordship, kindly consider.
When
That
an
is
order
why,
has been passed, the
My lord, the-
statute doesn't come into play.
my lord, rightly or wrongly, my lord, they have issued and he appeared,
No
she
scope.
appeared. Now, my lord, kindly give some time so that, my lord, the
1 week, otherwise I'll rule issue.
my lord, RTA board, since Lordship kindly consider, it's a RTA board.
Time has been
No,
granted. I cannot.
I'm,
grant
my
any
lord,
further.
Lordship kindly consider. Lordship, kindly
This
give
dividend
2
of
weeks time.
weeks is
My
not
lord,
acceptable.
because the member or the chairman, both, my lord, are to be, my lord, the present in the RTA board. So Lordship, kindly give, my lord, 2 weeks time. I have not much more than 2 weeks time. 2 weeks time, Lordship, let this matter appear before the Lordship, 2 weeks after.
4th October,
My lord, today as for the 4th
2
October,
weeks. 2 weeks.
4th October, my.
Otherwise, rule will be issued on the next day. Learned counsel for the alleged contemner seeks 2 weeks accommodation, weeks essay for apostrophe, to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 4th October 2023. Paragraph, affidavit of compliance be submitted by the alleged contemner on the adjourned date, comma, ID rule be issued.
My lord, another prayer, Lordship, kindly, my lord, that pendency of this contempt proceeding would not debar the authority concerned, my lord, to take the decision in terms of the order, Lordship, kindly. Pendency, otherwise you will
I
take.
is the same, no decision has to be taken. The order has to be implemented, that's all. You have to place the petitioner in the 24th vacancy. No decision, there is no scope for any hearing, no scope for any decision. Only the order has to be implemented, that's all. Because since it is not under challenge.
But in any event, my lord, this
And
is the,
since
this
this
is,
contempt application is pending, they have to implement it all the more. There's no question of this
my
all
lord,
being a
my lord,
part.
they have to. Only thing is that, my lord, this will not, my lord, debar the, my lord, authority to comply with my lord's order.
That is there.
The pendency of the proceeding, only this thing.
Not
Pendency
necessary.
of this proceeding,
Necessary. Since contempt is pending, you have to comply with the order.
Very
There is no other alternative.
my,
Next matter.
get advocate on it, advocate on it, advocate on it. Borun Kumar, sir.
106.
Report. You sir. Have you received a copy, Mr. Mukherjee? No. Mr. Devra, please serve in advance.
Sorry, my lord, extremely sorry. চেয়ে নিতে পারিস ওই যদি
আমি তো জানি না তোমার হয়েছে কিনা
my instruction is that
Mr. Mukherjee, will you be ready today or you want to
Please
go
not-
through the report?
বলে দিচ্ছি disclosure করে দেন. He is not file an application for transfer in a proper place. Temporary registration was made.
my lord, I think, my lord, altogether different submissions made by my lord. No, who is, my lord, my allegation is that the vehicle has been repossessed by the financer Now they made it transfer to a third party. And by flouting the provisions under section 51(5) and the motor vehicles rules, central motor vehicles rules. All are these, this has been complained of. No intimations, nothing has been given, 51(5). That is the issue.
If in an application for the ARTO Arambagh initially temporary registered temporarily. Temporary registration was made, subsequently it was transferred to Mathabanga. RTO Mathabanga, that's Kuchbihar. He did not made any application before the ARTO Shirampur, ARTO Arambagh. This is my report, Lordship. Kindly see.
This is your book, Mr. Mukherjee, here?
The book.
Yes?
No, madam.
দিদি এই বইটা এখানে রাখা আমাদের বই? হুম? একটা মোটর ভেহিকলস একটা আছে এখানে।
এটা তো সার্টিফিকেট অফ রেজিস্ট্রেশনটা কোথায় লাগানো আছে বলতে?
মার্ক করলো কিরকম করে?
সার্টিফিকেট অফ
এখান থেকে বই নিই। এটা কারো পার্সোনাল বই এখানে পড়ে আছে। This is some personal book of Ms. Majbi.
একদম ফর্ম কোথায় আছে? ফর্ম 37 চাইল্ড
না সেটা বলছি some personal book. Someone has to claim. কেউ চাইলে বলে দিয়ে দেবেন। Mr. Mukherjee's claim is that no opportunity was given to you.
No.
Yes, my lord, no notice has been served under section 51(5). Now, my lord,
Mathabanga, Kuchbihar.
no, how, my lord, this vehicle has been, my lord, your lordship, my lord. No, I am not on that. Yes, Mathabanga is also the party hearing. Yes, I think
Mathabanga has to apply.
no, why? Who has to apply? My lord, these are, my lord, kindly appreciate one thing. But let me, my lord, submit. Your lordship, kindly see. My lord, the page 14 of my writ petition. My lord, this is a copy of certificate of registration. 1 minute. The copy of the certificate of registration is there. This is not a temporary registration. What my learned friend is submitting, my lord, this vehicle was with me for a long time, but this is under, your lordship can see form 23 is for the temporary registration. Form 23. Page 14 of my writ petition. This is, my lord, the vehicle has been registered. What has been given to me? I purchased the vehicle, the financer financed to me. Now I failed to deposit, my lord, the installments. They repossessed the vehicle. Your lordship kindly count that I have annexed also, and they sold it to third one. And the vehicle originally registered, this number is originally registered with the registering authority Arambagh. So my registering authority is Arambagh. Then I have to make the objection before the original registering authority. That is the rule.
So how is Mathabanga involved?
So we have got information that they have transferred it to another place. That is in Mathabanga. There they transferred the vehicle and the address of everything has been changed. And I also, my lord, your lordship will find that, my lord, I also made, subject to my lord's correction, I also made the registering authority. Yes, my lord, I also made the registering authority. My respondent number 4 is the registering authority Mathabanga. Here, my lord,
in the array of, my lord, the respondents, I have made the party
Yes,
respondent.
I've seen that. I've seen that.
And also, my lord, the private respondent, that's the HB Finance. My lord, they have appeared also. Only thing, my lord, is that, and your lordship kindly appreciate one thing.
Dispute between financial and.
No. My lord, kindly appreciate one thing. My lord, come, my lord, central, my lord, kindly come to central motor vehicles rules. Central motor vehicles rules. My lord, kindly come.
The act itself also says service of notice upon the registered owner. Has that been done?
No application was made. How can I?
No, before transferring the,
No, I am not transferring.
before registering the name of the private respondent,
Arambag is not transferring. Any vehicle, it transferred to Matabanga. He has to apply before the Matabanga.
the vehicle is registered under Arambag.
Initially Arambag, temporary register.
No, temporary. What temporary, my lord? Your lordship kindly see.
Using the word temporary.
You see, that is now Matabanga.
Now Mathavanga, but it was originally registered with the registering authority. Now your lordship kindly see, my lord, my lord, kindly come to rule, my lord, Central Motor Vehicles Rule 62. Rule 62, sub-rule 1. Rule 60, sorry, Rule 61, Section 51(5). That is there. That I have already held. Rule 61, sub-rule 3. Of the Central Motor Vehicles Rule.
These are the two contingencies.
Then, my lord, the sub-rule 3, where the registered owner has refused to deliver the certificate of registration, well, sub-rule 3, the finance to the financer or has absconded, then the registering authority shall issue a notice to the registered owner of the vehicle in Form 37. Now, kindly come to Form 37. This is, they have to done Form 37. Well, Form 37, lordship, kindly come to Form 37. Which is appended to the central rules, Form 37.
Form 37, yes.
Your lordship kindly see, notice to the registered owner of the motor vehicles to surrender certificate. They have to ask me to surrender the certificate of registration. Who? The original registering authority. Statute is there. For cancellation and to issue a phrase. This has to be done by the authority.
Yes, Mr. Dev.
Well, the difficulty is that at the time of purchasing the vehicle, is financer, from the financer. Financer, my lord, signed all the papers. That is why all papers are deposited on his behalf. That is the difficulty.
On my behalf.
The
Still,
financer must be there.
a notice should have been issued.
Financer must be there. And who is the third party, that I don't know.
You know who is the registered owner, the original registered owner.
Registered owner is the
And you can
initially
serve
Arambag.
notice on the registered owner.
Registered owner originally Arambag.
Yes,
Subsequently, it was transferred to Matabang. This vehicle.
but the notice has to be served by the Arambag registry office. Because originally it was registered under Arambag and it's not a temporary registration as you say, it is an absolute,
Registration.
yes,
Of
it's
course,
a
it is
registration,
registration.
a
Registered.
full-fledged registration. Yes.
That was transferred. The petitioner also transferred because that is why he has to make an application. He has to make an application.
I don't know, my lord.
for that.
What the
Where is the provision for an application? There is no provision.
Then my lord, financer must be here.
It is the lapse of the registering authority. What is your prayer, Mr. Mukherjee?
While kindly see, prayer is, my lord,
It has been registered in the name of the private respondent
Yes,
in contravention of 51(5).
yes. And my lord, if your lordship only give me some time, then I shall produce my lord. Though it's an interim form, the order passed by a coordinate bench, there are the registrations, second registrations asked to be cancelled, and they have cancelled, let it be retained to the original registered owner. This is order of this court as coordinate bench.
That is the order that has to be passed in fact in this writ petition.
Because of non-compliance of every procedures.
There are certain mandates which have not been adhered to.
So Lordship, I leave, give me some time so that I can take instruction from Mahatma. What happening there?
You cannot,
What is their name?
you cannot improve on this.
No, no, whose name has been registered there?
Want to come back, come back. Let him come.
Whose name has been registered there, that has to be registered. Though following 51(5), I cannot.
No,
I cannot.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
But may I take leave, my lord?
Learned counsel for the state respondents seeks to take further instructions in this matter. Paragraph, let the matter appear under the same heading on 11th October. Please serve in advance whatever instructions you have.
October.
In this matter, I have filed an application addition of party.
My lord, in this matter, my lord, I beg to appear for the petitioner.
Have you served the applications? Shravan?
Yes, my lord.
You have objection to it?
Yes, my lord, I am filing my opposition.
Served?
Yes. I am appearing on behalf of the applicant number 2. My lord, my main objection to the, my lord, addition of party is, my lord, that they have no locus, my lord. They are operating, my lord, over different route, my lord. And their permits have been, my lord, issued by a different authority. I am operating over the route, my lord, from Bardhaman to Boai Chondi, issued by the RTA Bardhaman. Mr. Dilip Samanto's client is operating by permit issued by the RTA Hooghly. And Mr. Khan's client is operating on a permit issued by RTA Bankura, my lord. Therefore, my lord, they have got no locus, my lord.
That is not the law. Law is, what is the route?
And my lord, how can they object against the renewal
My
of
lord,
the
alleging
permit, my lord?
pendency of the petition, they have been, he has been.
Permit has already been renewed. I am giving to
Pursuant to your lordship's order, my lord.
only the,
Only
yes.
timetable, classing of
Only
timetable
the
was there.
timetable is,
My lord,
late.
timetable, he has no timetable, he has no permit valid.
Permit has been.
Even the permit is illegal.
You have to challenge it in that case.
My lord, challenge, my lord, because he has, because of the pendency, he has been operating the vehicle without approval of timetable.
I have got provisional timetable, my lord.
But I can show you, if you lordship grants me leave, here and now I can produce all these things.
My lord, a provisional timetable has been issued by the RTA.
What?
So my application for additional party.
Yes,
My
Reply this to-
application for additional party.
yes.
The petitioner, my counsel of the petitioner, filed the evening opposition. I given the reply. The reaction, my lord, last petition, my lord directed, filed the affidavit. Because they paid for every read. Against the application additional party.
Lord, they are only complicating the proceedings, my lord.
No, 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 not at all.
This is the only intention,
Very
my lord.
plain, very
My
simple.
lord, my lord, in collusion with the RTA, my lord, my vehicle was also seized, my lord, and released by the order of this honorable court.
Entire action is based on
They are in
fraud.
collusion, my lord.
State are appearing in this case as the, for the state.
They are in collusion, my lord. They don't want me to operate over the route, my lord. My route, my lord. That is the thing, my lord.
What case? Because he is not the permit holder, and he obtained the order by practicing.
Serious illegality.
For this is my lord, we have come here. Just satisfy your lordship. And not only this, my lord, if affidavit has been affirmed.
Well, our application may be added, my lord, whether we can file an opposition to the petition.
Please explain your locus. How are you affected by the order?
My lord,
passed
yes,
on-
my lord. Kindly see my application, my lord. Application of can 1.
What is the prayer in the writ petition for issuance of timetable?
My lord, renewal of the permit and my lord, timetable, renewal of the timetable, my lord, issuance of the timetable.
Who has applied for renewal? Who is the holder of the permit and who has applied for?
No further submission on permit because the registering authority has confirmed that permit has been renewed. Only the timetable part is left.
My lord, timetable, my lord, the application for
So if you are agreed, you have to.
my lord, application for renewal is vested with the applicant, holder of the permit, not in favor of others.
It is the submission of the authority on the earlier question.
My lord,
Then how the permit was renewed, my lord?
Without controversy here, my lord, that is when the lordship can direct the authority. Direct the authority to question of the court to consider the entire grievances and enter all parties.
No, your submission on the earlier date, SUVRA was, you have said that the permit has been renewed and renewal of timetable shall be considered by the authority upon dealing with the objections filed by some of the operators, including the clients of, they are the other operators, I'm sure.
Regarding subsequently, it was found that the permit has been renewed wrongly. Which is not the owner of.
Has the authority taken steps?
That is why they due to the pendency of the dispute, they are not.
Why will the writ petition preclude the authority from taking steps? Writ petition is on a different ground altogether.
When my lord is sitting the matter, I cannot directly to.
Have you submitted any report in this matter? Have you submitted any report?
No, my instruction is there.
Stating the facts that,
On instruction, they are.
My lord, let him submit a report, my lord. I will deal with
No. By this process, you
Yes, my
cannot
lord, everything
continue the illegal operation.
everything we will.
No,
before
no.
your lordship, my lord. If a report is filed, my lord, whatever irregularity is there, it will be decided by
You
your
have to
lordship.
stop your operation of vehicle. Without valid timetable, we cannot operate.
how are you operating without a valid
This is the
timetable?
timetable, my lord, that I have been renewed, my lord.
Valid
Provisional
till?
time. My lord,
Valid till?
my lord, this is until further orders. Kindly have a look, my. Until further orders, my lord, till my permit, my timetable is renewed, my lord. Until further orders on the left hand side, my lord, is the endorsement by the RTA.
But that is cannot be done. It is the.
Who has issued this?
It's a
The secretary RTA, my.
But
Because the
that-
permit was renewed, my
That
lord.
is a format, my lord, timetable.
Vehicle cannot stand idle, my lord. It has to ply, my lord, after. the
By
permit
this
has-
process, secretary is doing all these
My right
things.
to business will be affected, my lord.
But secretary, I am lodging complaint against the secretary. He's the mischief maker.
Do that.
Yes,
That has been closed in the evening opposition.
they are in collusion with him, my lord.
Where is it stated that until further orders? I
My lord, on
cannot
the left
find
hand side, there is an endorsement, my lord. If your lordship so desires, I'll produce the original copy, my lord. If it is not so clear, my lord.
one month.
Yes. My lord,
That 1 month
until
is
further
okay.
orders, my lord. Until my lord, the renewal of the timetable, my lord. And I am
Where is
flying.
the language until further orders? Please show me. Till date, the timetable as was.
It is not very clear, my lord. We'll produce the original one, my lord. Tomorrow, if your lordship so desires.
Please show me that it is valid till today.
Yes, my lord. I will show it, my lord.
ফেরত দিন তো।
Man, he has no timetable. He has entire renewal is illegal. Man, a permit holder is one other person, and he has been got the permit renewed by another person.
He has never permitted.
Now the authority says wrongly done, and mischief.
No amount of passage can cure this illegality. So this illegality should stop. Otherwise,
Yes, but it should be done with a particular time. Let him stop his operation of the vehicle. He has to come before the court with clean hands. The primary consideration.
By practicing fraud, he obtained the.
My lord, I have underlined that part, my lord, the old timetable.
And this is not the way. Timetable is not cannot be renewed by this process.
My old timetable, my lord, I will be allowed to run till, my lord, it is renewed, my lord.
That cannot be,
My lord, I will produce
it is
the original
also
copy.
disputing. We are disputing, my lord.
Yes, where is it stated that it is continuing till date?
My lord, I will bring the copy tomorrow, my lord. Kindly post the matter for tomorrow. This is not very clear,
How can the original be different from the copy? I can read this. This is legible.
my lord.
Where is the language until further orders as you've just submitted? I do not find that language here. So please stop plying your vehicle till the matter is disposed of.
My lord, let me produce the original tomorrow, my lord.
Till date, the timetable as was something. The date is 3rd August 2022.
Yes, my lord. That is the last time,
After that, there is no renewal, no
my lord,
extension.
because writ petition was pending. my lord.
The challenging pendency has been operating.
Mr. Shah, check your blood pressure. I would request him to check his blood
I'm
pressure.
sorry, madam. I'm sorry.
To take care of your health, Mr. Shamanta first, then all the cases.
I'm sorry, madam. I'm sorry.
Have you come to court with clean hands? Yes or no?
My lord, after the permit has been renewed, my lord, the
You
RTA,
have just now submitted
yes,
that the permit is valid till date. Now you say that
Yes.
due to pendency of the writ petition, it
My-
was not extended.
no, my permit is valid
Has
till,
your client come to court with clean hands?
my lord, the permit has been renewed till the year 2028, after your lordship's order, my lord. So, my lord, if the permit has been renewed, can the vehicle stand ideal, my lord?
Absolutely wrong submission because there is no
Third
order.
learned counsels for the parties. Paragraph. It has been initially submitted on behalf of the petitioner that the permit granted to the petitioner was extended until further orders by the Secretary RTA Purva Bardhaman. Stop. Learned counsel subsequently submits that the permit was not renewed any further after its expiry due to pendency of the writ petition. Stop. It prima facie paragraph. It prima facie appears that the petitioner has not come before this court with clean hands and has deliberately suppressed material facts before the court. Paragraph. The all affidavits complete. Do you want to submit any further document?
Madam, I have not filed any reply, my lord, because I filed the application, madam, stating all facts, my lord.
You don't need to file any reply.
I replied, I have
It is
not
my
filed.
application, or I bring
I
opposition.
have not
file, I
filed.
bring-
But in my application, I have stated everything, my lord.
Paragraph.
Application number 2.
Affidavit in opposition submitted on behalf of the petitioner against the applications and affidavit in reply submitted by learned counsel for the applicant in Can 2 of 2023 are taken on record. Paragraph, let the matter appear under the same heading for further consideration on 13th October.
Madam.
Paragraph, the petitioner is restrained from plying the vehicle in question till disposal of the writ petition.
My lord, kindly record my statement, my lord, that the permit is valid till the year 2028. Kindly record one sentence, my lord.
It is recorded.
My lord, this is the order, my lord. This is your lordship's order, my lord.
Doesn't come to court with clean hands is not entitled to any relief whatsoever.
My lord,
And prima facie it appears you have not come to court with clean hands. Next matter,
Madam, can application pending, will not allow, my lord.
pending.
My-
I'll consider all of them together. Yes, কবে বললাম? 13th October.
All my affidavit in reply.
একটা অপোজিশন একটা রিপ্লাই আসবে রেকর্ডিং শুরুতে না। দুটোই ক্যানের কিন্তু অ্যালং উইথ ক্যান 1 and 2 করে দেবেন আলাদা কথা হ্যাঁ। সেটা
তো পরে এখন তো নয় নয় তো
রিপ্লাইটা 2 এর অ্যাপ্লিকেশন করে ছেড়ে দিন ক্যান 1 দেখে দাও
না, না।
রিপ্লাই 2 এর খালি অ্যাপ্লিকেশনস বাস হ্যাঁ
প্রাইভেট রেসপন্ডেন্ট তো নেই এখানে
খালি Reply to 2 of 23.
কোথায়?
Yes, next.
308.
But I am for the petitioner with Mr. Nondi. Now, my lord, on the last occasion, you lost
Respondents?
Mr. Devray.
Mr. Devra?
This is the exception to the report.
Exception to the
এটা দর্শককে দিয়ে দিন।
copy served.
Yes, yes. Just now. It's no doubt just now. Now, my lord,
You are ready, Mr. Devra? You want to come back?
Big exception.
Big exception.
I have not seen the exception. Mr. Nondi has written. He has
Served a
served.
day earlier.
Yesterday, at the.
He wasted a day, no? He served it. Come back
When I shall come back tomorrow or day after tomorrow.
tomorrow. I'll give you a date. Exception used by the petitioners to the affidavit in opposition submitted on behalf of the respondents is taken on record. Paragraph copy of the exception is made over to learned counsel for the respondents in court this day. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 6th October. Week after.
6th October. Now, my lord, only thing
Report in
is,
the form of affidavit.
only thing is this, my lord, this matter challenging one resolution. My client has filed this petition. Next matter, Mr. Khan is appearing on behalf of the writ petitioner. He is for the implementation of the writ
Oh,
petition.
so both should be taken up
So, my
together.
lord, what I am praying, both should be taken.
That they should be taken up together.
Yes.
So the next matter by consent, let me fix the same date. Didi, next.
309.
The petition at 6th October.
6th October.
By consent of the parties, by consent of the parties, let the matter appear under the same heading on 6th October.
Now, my lord, only thing in my writ petition, Mr. Khan is not a party. In order to expedite all these things and to be shorten everything, but what I am praying in my oral prayer, your lordship kindly add Mr. Khan's clients as a party respondent in my writ petition.
Are you a party in the?
And accordingly, also to be added my clients
Party আছে.
as, already we are in the party. We have party. So let Mr. Khan's clients be added as a party on my oral prayer.
First, in 308.
Stop a copy of the
Yes, yes, only. Yes, yes. Copy will be served.
Client details দিয়ে দিন।
Client details set to দিয়ে দিন। আরে তুমি ওকে দিক ও অ্যাড করে দেবে।
আপনারা আমাকে একটু দেবেন, প্রোভাইড করুন। আচ্ছা।
দর্শক তো লিভ দিচ্ছে।
308 একদম প্রথমে করুন।
পার্টিকে অ্যাড করে দিন। আজ কন্ট্রোভার্সির মধ্যে থাকবে না।
On prayer of the petitioners, liberty is granted to implead.
Implead, এই ওর নামটা বলো। Your lordship is 1 minute.
Give the details, please.
Ganesh
As-
Chandra Datta.
Give the detail, please.
Yes, yes.
As respondent number 10 in the writ petition.
Yes, yes.
Paragraph, the cost settle of the writ petition is be amended accordingly. Paragraph, the petitioners are directed to serve copy of the writ petition along with annexure thereto upon the added respondent. Are you serving it here and now?
Here and now.
আমি জেরক্স করে জমা দিই।
In course of today.
In course of this day.
জেরক্স করে। হ্যাঁ। দুটো নাম বলে দিন।
Well, there are two writ petitioners, two persons to be added, Ganesh Chandra Datta and Gopal Samanto. No, Shobita Samanto, 3.
11, 10 and 11. huh?
3, 10, 11, 12. 10, 11,
persons.
12, 3 persons.
10, 11 and 12. তিনজন add হচ্ছে। 10, 11 and 12 যেটা বলছি সেটা লিখুন। 9 অব্দি আছে।
মার্ডারটা এক্সপিডিয়েট হয়ে ম্যাটটা শেষ হয়ে
1, 10 বলেছি তো 10, 11 and 12 তিনজন add। ওটা একটা লাইন একটা যেখানে ডাইরেকশন দিলাম না petitioner directed to serve cost that will be amended accordingly তারপরে করুন since Learned Counsel, Mr. Khan is appearing for the added respondents who are writ petitioners in
16629.
WPA 16629 of 2023, the petitioners are directed to serve copy of the writ petition along with annexure thereto upon Learned Counsel.
Junior of Mr. Khan. এই তোমার নামটা বলো তো?
Learned Counsel in course of this day. Taपर let the matter appear.
ওটা দাও 208 নামগুলো লিখে এইটা অ্যাড করো,
আমি করে দিচ্ছি।
গণেশ চন্দ্র দত্ত।
Next.
Well, in this matter, I'm appearing on behalf of the petition.
I am appealing for the state league by Mr. Khan.
But here in this case, we are operating the contract carriage permit in respect to auto rickshaw in different routes within the territorial jurisdiction of district of Nadia. So I managed to allot all these permits in this writ petition from page number
Mr.
17.
Khan, microphone.
From
Mr. Khan, microphone.
Page number 17 to page number 24. All those smaller permits have been annexed in this writ petition. One of the route is Milo Nalaghat, Courtmore to Ramanwar Ghat, and different routes, my lord. That permit was valid till the substantial period of time. Now, the state government, Transport Department, Government of West Bengal, adopted a policy by a notification dated 29th January 2010. I have annexed that notification page number 25.
Yes.
Regarding the restriction of the grant of permit in respect to auto rickshaw, last annex, paragraph 6, page number 28, grant of three-wheel auto rickshaw permit within a particular district only may, however, be considered by the concerned RTA of the district after taking into consideration the road condition, congestion, road traffic, and safety of security of the passengers. So, my lord, several permits were issued on the different routes. But actually, there is no stand. All the vehicles were parked on the road. So, my lord, every day, my lord, they are facing, my lord, trouble and accident occur every day. So, for this reason, my lord, we have made a comprehensive representation before the Regional Transport Authority Nadia, page number 30.
Yes.
In support of this government policy. And authority will consider my representation after taking into consideration all the aspects which are stated before the authority by way of representation, page number 30.
Is
Although
there
Kali
any
that
vi-
present may
is
be
there any
considered.
violation of provision?
Sanjay Bishop.
Is there, are you complaining of any violation of the notification? No.
Nothing.
No violation.
So you
There-
cannot direct the government authority to follow a notification,
Not to implement the notification.
not maintain it.
First of all, my lord, no specific complaint,
We are granting
no
permit.
specific complaint that this is the violation or these are the violation.
Yes.
Number one, number two, এবার একটু বলতে
No, no, I'm শেষ হয়নি তো।
তুমি শেষ
There is no
করতেই পারবে না।
sufficient space. But then I have stated everything in my representation. I'm not taking
Nothing,
the violation.
that these are not the everything.
Not complaint violation.
Yes,
You can come before a writ court when there is violation of a notification.
yes.
For that.
An aggrieved person
You
can come,
cannot
yes.
advise the government
But they are,
to implement.
but kindly see the prayer. They are
But what
granting the
prayer?
permit.
No, where
Granting
is
more
that
permit.
specific
But there is
allegation?
sufficient space.
There
are the
is a
prayer.
specific
It is the prayer of-
allegation.
There should be a specific allegation.
You are not complaining violation of the notification.
No, but not violation of the notification.
You
Yeah,
are-
violation
then-
means my lord.
You have become an advisory body to the government. You cannot do that.
All right, Mr.
You are
Authority,
advising
there is
the
no
RTA.
sufficient space.
যা
There
কিছু
is no
দেখলেই
sufficient space to
representation হয়।
accommodate the vehicle in the terminating.
No, we, authority is not
That is
supposed to
the-
look into this
That is
type
the
of
responsibility of the authority.
consideration.
Policy, but this is a policy of the government. The government authority may,
How, when can you come before the writ court when the policy is not followed by the government?
in support of condition number 6, authority examine my prayer is right or wrong. Nothing else.
What examine?
There is no allegation at all. It's a premature. repetition.
They have started every day, they are granting the permit, or there is a chance of.
Come up with a
Have you
specific
stated that-
allegation that,
You've
that this
stated
is the
that in the
violation.
petition That they are granting permits in
Yes.
violation of the notification. Where is that allegation?
Violation, my lord, these are condition, can you see the condition?
আরে condition ঠিক আছে।
Can you see the condition of the notification?
Your prayer is,
Prayer is, my lord. When was prayer here?
And that too, my lord, the entire, my lord, the Ranaghat from other area.
Prayer
Just
here.
kindly have a look. Almost entire, my lord, a part of the district covering,
As to why.
not
they
a
found
single
that
route or a single area.
Did not act in terms of was clause 6 of the notification dated 29th January issued by the Transport Department, Government of West Bengal, and further to show as to why they have to continue to grant further.
What type of these prayer is this?
Problems of congestion in regarding of safety and security of the commuters.
Any
in the
entertainment,
petition, where is your allegation of violation of the notification? Please show me. In the writ petition, paragraph.
Violation,
no, my lord, any lordship kindly consider, yes, my lord, what fell from your lordship exactly correct. Any entertainment, my lord, that means that there is violation. When there is,
paragraph 6.
there is no specific allegation of violation.
Paragraph 6. That in spite of pointing out before the Modi authority regarding the aforesaid problems of congestion, extreme inconvenience of
The
the terminal
general-
points regarding parking
general
of
alarming.
vehicles, the Nodia has paid deep ear to such complaints made by the authorities.
What is
in
the-
India and are continuing to grant further
Let us
permits
see,
to the
what is the
aforesaid route
complaint? What is the complaint? Where is the complaint? Let us
My
see.
simple prayer, my
No,
lord.
no, the
I have-
prayer may be
we have-
simple,
we have brought
but you have come up in a read
the
code.
present problems before the
Not
authority.
so simple.
Where is the violation in paragraph 6? Where have you stated that it is in
Anything and
violation of the
everything cannot be
notification?
directed to be considered.
Violation,
stated.
violation means also a large number of permit is continuing.
At least one,
In representative, I have said so. in
one, two,
representation,
what
first is
representative?
permit.
Where you have said it?
They
Nothing.
give a lordship, I direct the authority to take.
Show the
action.
representation. Come to the representation.
Yes.
And representation cannot be beyond the four corners of.
Yes.
No, beyond the support of this notification condition number 6.
Nothing.
I
In
cannot.
the
Because as per
representation,
liberalized, I have no
entire
right.
Nodia
But
district,
I
he has
s-
mentioned
Come on, as per liberalized policy, I have no right.
several
Because
routes.
I am supporting the condition number 6 of the notification. It is the policy of the government.
You must come up with a specific case.
Specific case. because
Where
they
is the
want to
specific
say,
case?
Where is
No
the
specific case.
Where have you alleged violation? What is the, you have not asked for any specific relief.
If I, in this, may I read it from beginning?
Cannot.
Beginning of what?
Only notification, representation. I've stated everything, so.
Oh, everything.
Paragraph 3, paragraph
Please
3.
show me the paragraph where you have stated that you are issuing in violation of the notification.
আরে একই কথা তো বারবার
You have
my lord
issued
জিজ্ঞেস
permit
করছে
in violation
specific
of the
allegation টা
notification.
কোথায়?
Please show me that allegation.
Page number 33.
Yes,
Page number 33,
Yes.
from first paragraph, first line, that in the said area, that is Ranaghat Court Mode, Haradhan Ghat, Ranaghat Station, Sitpur Ghat, Ravon Board, there are no specific terminal point.
These are to be looked
And the
into by the
authorities are being
well.
compelled to be parked on the said, on the road at the roadside. It is stated that extreme lawlessness situation are prevailing in the said area, as numerous auto rickshaws and magic vehicles, trekkers and illegal e-rickshaw plying in the said road.
Somebody is
and other
applying
roads
there,
without
so
any
they are
valid
now
permit and
come up
spite
in
of
the read
causing
code.
several- why you-
This is all, my lord, by the, my lord, the existing operator
Complex in this
set up.
regard. No
some
steps
person.
has been taken by the Regional Transport Authority Noida to mitigate the problem of congestion and to stop such illegal flying auto rickshaws, e-rickshaws, trekkers and magic vehicles without any valid permit. Apart from that, the Regional Transport Authority and Noida are continuously granting new auto rickshaw permits in the aforesaid route in spite of the fact that the roads of the alignment of the road is extremely congested and is accident prone to the detriment of the commuters and pedestrians at large. It is further stated therein that the police authorities are absolutely aware of the fact that several accidents have occurred in the said area in the present past due to extreme congestion of the road and particularly the terminal point. Any grant of further permits in the aforesaid road is highly unwarranted and is false contravention, violation to the clause 6 of the notification dated.
Let them
29th
file any
November 10,
public interest litigation if they show thing. If they show thing that public at large are going to be affected, let the public interest petition.
All
But in the
trans-
motor vehicle jurisdiction, they should come up with a specific case that this is the violation of the law. In general, whatever he my landed point my lord read out, this is in general he say,
Advise me to go to public litigation.
this is not the question of advice. When you are coming with an advisory, my lord, they say that everything, anything and everything cannot be going to. Who has filed these? What is the actual, my lord, the motive? I do not know. But the thing is this, that when you are coming for the, my lord, the interest of the public, then it should be, my lord, before the public interest litigation, there should, he should file this.
Congestion, accident, all these are public interest.
Yes. What no?
Operator cannot go there.
Cannot go
Now you have
These are
say
private-
that you
private
are for
litigation,
operator.
not the public litigation, private litigation. Private litigation can go.
Now you say
If
that
one
you are
gets followed,
operator.
that goes for the court.
So you are operating and you say that the any further permit, that means that the congestion, that you cannot say. That you cannot say.
No, authority only examine that clear.
And when we say, my lord,
What is
the,
the problem?
what
Your
examine?
operations in the same route? No.
Same route.
No, here the my lord at this, my lord, I do not
Same
know how
route.
many routes are it. Lord, say kindly consider this, my lord, his
How many-
representation. My lord, it's a, my lord, representation, consider, my lord, half of the, my lord, the Nodia district.
Yes.
Ranaghat More, Haradan
Another
Road,
district.
Ranaghat Station, then my lord,
Particular route.
huge area, lordship.
No.
First,
Only
please,
the permit holder.
every time, no, Corona. Ek dhojjo rakho. Page number 31. Page number 31, first paragraph. Half of Nodia district, we say,
Entire
almost.
Nodia, yes.
Half of Nodia district. Now, without any mentioning any further, any particulars, the authority, how they will do? Yes, in this particular,
I am the permit holder because I am the permit
You have
holder
to
of
be
this
more
route.
specific.
is
in
not
your
possible.
repetition. You are asking for a blanket order.
No, we are the
God,
permit
no.
holder of the particular route. That route has been mentioned, not other routes. I have mentioned the other route.
Can it be
We have
several
mentioned the
routes?
route.
must
which
be
we have got
a
the
specific
public-
case, otherwise, my lord, it is not
And
possible.
this is like a mass petition by the entire Nodia operators.
Yes.
Yeah.
This
It's a-
is
it
by
may
the
be a
all
big
the
case for
operators of
public
entire
interest.
Nodia. It's a mass petition.
No, it is not the mass petition because I am the permit holder. I have met the request before the authority that I am permit holder. We are facing this. If
They-
the further grant of permit.
You have no
With
right
separate
to
petitions.
restrict the others.
Since the routes are different, come with separate.
No, not different.
petitions.
We are the permit holder. I have annexed the permit.
4 or 3
We are the
permit
permit
holders
holder of this route.
in respect
I am
of,
not
my
the-
lord,
I
the
have mentioned
half
the
of
other
Nodia
route.
district, and says that
Yeah,
illegal,
court fees. I
illegal.
get Legal court fees also.
All the permit holders in the same route?
Same route. Not same route. Same route, different routes, but I paid the individual court stamp because they joint petition mental on payment to individual court
But that
stamp.
is not the
order of
factor,
Supreme Court.
whether he paid the court fees or not. First, on a preliminary issue is whether, my lord, this writ petition, my lord, is maintainable in his present form.
But can the operators approach the public interest litigation bench?
My lord, the operators on earlier occasion, they have approached. Now the question is, my lord, if it is a public interest litigation, there are, my lord, this is not a single, my lord, paragraph that this is that we are we are aggrieved person. Says that all the time, says that no more permit be given because of congestion. So no more permit be given because of congestion, then let them, my lord, whatever. The person who seems to be that aggrieved person because of congestion, let them go and file the public interest litigation. But because, Lordship, kindly consider, otherwise, an operator, he has no right to restrict the, my lord, the authority concerned when it's a free route so long.
That is
Now
also-
this
I
is
also
an,
made the same submission
now this is, he says
because I-
that there is a clause.
we are facing
Now
this-
if,
Wait.
please, to me, to bolte dao. Now, if the thing is this, that in violation of that particular clause, any permit has been given, then let them challenge the said permit, let them come up with that particular clause. That yes, there is the, otherwise, how can, my lord?
I will release the matter holding it to be a public, because your last line is also for the interest of safety and security of the public at large.
Yes, public at large.
You are not asking for your own interest.
No,
It's for the interest of the public at large.
he has not said
We are
that
the
he is an
permit
aggrieved
holder,
party.
We are facing problem.
Last line of your repetition, representation.
That the undersigned along
So
with.
you're
the other-
concerned about the
Extremely
the
for the
public.
interest of the safety and security of the public at large. I'm grateful to your lordship.
Even prior to that, ensure the safety and security of the commuters and the public at large.
Yes,
Everywhere it
on
is
the
public at large.
earlier paragraph also. Earlier paragraph. also.
Security of the public.
I leave it to your lordship. my
Send
lord. I
We have
think
both
yes.
sides.
Please approach the appropriate
Mine.
bench. The Honorable Chief Justice deals with this, not me.
My lord, may I submit nothing?
No, nothing.
My lord, public, my lord, liberty may be to face, make a face representing approaching law. That may be.
Your
considered.
writ petition, what about the writ petition? It also says public interest.
No, like fresh representation before the authority and liberty may be.
It should be a fresh writ petition then, not representation.
Not representation.
Your writ petition also talks about public interest. Writ petition. That is also public, the entire issue is on public interest. You can withdraw, I can release it.
Actually, I am challenging the my lord government policy that I should support of this. that the
Paragraph
authority
7,
can-
last line, to ensure safety and security of the commuters and public at
Yes,
large.
because
The
remember
representation is
a grant of
reflection of the
permit is not
petition.
bill. A grant of permit not be for the benefit of the operator. It is the grant of means of the convenience of public. So that authority, the public can face the accident or also any other problem. For this
So
reason, my
you are
lord,
concerned with the public. So it is a public interest litigation.
public means of the computer.
That is the
I
exact
think
definition.
there would not be any problem to go before, my lord, the
My lord,
number
this-
one and
What's
my lord,
else?
file a public
Consider
interest
my
litigation.
nothing.
No,
No.
can't be. There is no specific,
No, I,
Key
the
consider.
chief asked for. The matter,
but at least can give me liberty to
The-
make a fresh application.
the,
according to
it
the law.
is-
Fresh application. fresh-
your writ petition
No, no,
says,
representative, no.
the writ petition says for the public, interest of the public.
Representation করবে কি না
How will
করবে
you
তার
change
জন্য
your writ
liberty দিতে হবে।
petition? Representation is a reflection of the writ
Yes.
petition. Writ petition says you're asking for the interest of the public and commuters.
That is properly commuters means with passengers. Commuter means passengers.
তার মানে
Not-
public,
And you
not
are
for you.
operators, you are not passengers. You are operators.
বাজে কথা বলবো।
Simple free her.
No, no, no.
Logic is the better junior.
The subject matter of the writ petition
Representation.
is in the nature of a public interest litigation. Paragraph, the matter be released
কি হলো?
due to lack of determination.
হচ্ছে, ধরেছে যে।
My lord, we are not interested, we are not going to move the. this,
ও যাচ্ছে তো।
legal
Yes.
litigation.
ওসব বলে দিয়েছে, উল্টো করে নিচ্ছে।
That's it. Next.
Get
Really?
কতই?
311.
Yes. Well, in this matter, we are paying on behalf of the petitioner. Yes, sir.
Only Ukino? Is he a learned advocate?
My
Is
lord,
he a learned
No, no, no.
advocate?
Class.
Smartness is good, over smartness is not good.
Sorry. But here in this case,
Who is appearing for the
Mala, I
respondent?
am mentioning
Mala,
one of
I
the
am.
petitioner. Mala, here in this case, the petitioner, my lord, is the dealer of two wheelers. Oh, manufacturers, my lord,
451.
and a Hero Motorcorp Limited is a manufacturer. Well, I obtained a trade certificate under Rule 34 of the Central Motor Rules 1989. Well, initially, my lord, I applied for trade certificate under Rule 34 of the Central Motor Rules 1989. Along with the form number 16A, because the form number 16A that issued by the manufacturer to the dealer. And on the basis of that application, I obtained our trade certificate. Thereafter, my lord, I started to run my business.
Started to? Take the microphone, please, you're not clear.
My lord, according to my lord's section, the Rule 34, kindly see the Rule 34 of the Central Motor Vehicle Rules 1989.
Yes.
My lord has got it. Rule 34, trade certificate. An application for the grant or renewal of a trade certificate shall be made electronically on the Bahon portal in Form 16. My lord, this was amended. My lord has
Yes,
got
this
it.
has been added.
In
It's
Form
not there.
16 and shall be accompanied by the appropriate fee as specified Rule 81 electronically. Provided that the application by a dealer of motor vehicle shall also be accompanied by a dealership authorization certificate in Form 16A issued electronically or on portal by the concerned manufacturer of motor vehicle.
That this book doesn't have the amendment.
34. But
This book doesn't have the amendment.
oh, why not this amendment copy? Let us.
Do you have a spare copy?
Yes. আপনাকে চাচ্ছে তো কি নতুন বইটা রুলস
কত দাঁড়াও আমারটা অ্যামেন্ড হয়েছে কত যেন বললে রুল
Rule 34. Rule 34. Rule 34. My lord, a dealer, my lord, will make an application. But that was amended.
Yes.
and-
2022.
Yes.
1st November
Yes.
2022.
আপনার কপি দিয়ে দিচ্ছি
এটা অ্যামেন্ডমেন্ট হয়েছে
কপি দিচ্ছি নতুন বই থেকে যে আপনিও নেন Only dealer
Yes.
will make an application under 16, form number 16, along with form number 16A issued by the manufacturer. On the basis of that application, trade certificate issued under Rule 35. Next, 35.
Yes.
Trade certificate will be issued by the registering authority. Grant or renewal of trade certificate on receipt of an application for the grant of renewal of a trade certificate. The registering authority may, if satisfied, issue to the applicant trade certificate electronically on portal in download available and printable form in form number 17 within 30 days from the date of receipt of the application. Now, I obtained this state license following the Rule 34 and 35, in compliance of Rule 34, 35. Thereafter, my lord, I carry on my business of the dealership business, and my lord, I engaged several sub-dealers. Under the Rule 75 of the West Bengal Motor Rules 1989. Now can you see the rule? At first, rule definition of the rule. Definition of the rule. West Bengal Motor Rules 1989.
Yes.
Rule definition. Rule 2 of the West Bengal Rules 1989. B1's definition of sub-dealer. B1 definition of sub-dealer. All right, has got it.
P1 is computer service fee.
Sub-dealer. All of the STUV1.
Oh, V.
V1. After
V1, sub-dealer, yes.
V1 sub-dealer definition. Sub-dealer means any person or agent or company engaged in dealing with an unregistered vehicle under the authorization of any authorized dealer of such vehicles. But that means, my lord, sub-dealer is engaged in dealing with an unregistered vehicle under the authorization of any dealer, authorized dealer.
Yes.
Now, my lord, authorized dealer is not entitled to apply for trade certificate. Trade certificate, my lord, dealer applies. Dealer can apply. Now, my lord, without license, the sub-dealer can run the business or not. Now that procedure has been, my lord, prescribed in Rule 75. That means, my lord, license for business is required in case of sub-dealer. Now 75, rules 75. Bengal.
Rule 75.
75. Rule 70, because for each and every chapter of the Motor Vehicles Act, rule making power, state has the rule making power. Well, a rule is the legitimate aid to the construction of the statute. In absence of the rule, act cannot enforce. So, a procedure has been laid down in case of sub-dealer, for license for business. My lord has got it 75,
Yes,
75.
yes.
My lord, sub-rule 4, that was amended in the year 2005 also.
Yes.
No authority to sell or deal with or to keep in possession any motor vehicle shall be granted to any sub-dealer in any area within the state, provided that the registering authority in whose jurisdiction the sub-dealer has his place of business grant license for such business on an application to be submitted by the sub-dealer. Provided further that such license for such business shall be given on realization of fees as specified in Schedule A, and also on such condition as may be specified by the order of the state government. That means, my lord, no authority or sale to deal any vehicle shall be granted to any sub-dealer unless he obtain the license for business. How he will apply for license for business, that has been laid down, my lord, as per government notification. But that notification issued, my lord, under Rule 75, sub-rule 4. Rule 74, sub-rule 4. My lord, that not available in the book. I am giving this type copy, my lord. Yes, there is a copy from my book. যে রুল নোটিফিকেশন হয়েছিল আপনার কাছে আছে এই যে দেখুন মালর has got it.
Rule
serial number 39, that is available in my book also. Conditions of issue renewal of any license. Notification number dated 12 January 2005. It's notification in the year 2005. I handed over the copy of this notification.
Rule 39 is restriction on the holding of
No,
license.
not rule 13, notification 13. Serial number 39, notification condition of cease. But this is not the rule.
This is the notification.
Notification. So I just have place. But that is not brought in my book also. I have at the last page of this book, this notification. Yes. So I have the Xerox copy of taking this from the in exercise of the powers confirmed upon under sub-rule 4 of Rule 75 of West Bengal Motor Rules 1989, the governor is pleased to order that issue renewal of any license under this rule shall be subject to the following condition. The application for license shall be made to the registering authority of the jurisdiction of form SDL. SDL means sub-dealer license application. SDL sub-dealer license appended to this order with the prescribed fee and shall be accompanied by the letter of appointment as sub-dealer issued by the dealer appointed by the manufacturers for the type of vehicles for which the applicant applied, and having valid trade certificate issued Rule 35 of Central Rules 1989, issued by the registering authority having jurisdiction. A trade license issued by the appropriate authority is also to be furnished. In case any sub-dealer operates as an agent or more than one dealer of type vehicle or more than one manufacturer, the fee is issue renewal of the prescribed rate is to be paid against each of the dealer or manufacturer as the case may be. Subsequent the issue of license, any prayer of the sub-dealer for addition of dealers or type of vehicle of manufacturer that is not mentioned in the license may be allowed subject to realization of fee calculated as above, but the validity of the license will remain unchanged. The issuing authority may allow deletion of any dealer or manufacturer mentioned in the license at any time if paid by the concerned dealer or the sub-dealer with required documents. The applicant shall have appropriate showroom premises for display of vehicles and of proper godown for keeping the stock of vehicles. No vehicle other than the type of vehicle mentioned in the license or not included in the stock of dealer concerned or not covered by the trade certificate held by the dealer concerned shall be kept in the stock of sub-dealer. The regulation prescribed under same rule for use of trade certificate will also hold good for any vehicle in possession of the sub-dealer and used in any public place for the purpose and direction in the concerned trade. The sales certificate in form of printing same rule 99 of any vehicle sold by any sub-dealer shall be used by the corresponding dealer of that particular vehicle. The license of sub-dealer shall be issued in form SDA. One license will be issued under SDA.
What is his prayer?
I'm going to
No doubt, my lord, what he is, my lord, reading, these are the provision, my lord, after amendment, these are the provision. Well, we have, my lord, there is no question of denial. Now, the thing is this, what is his prayer?
prayer.
So kindly consider and whether
I'm placing only one issue.
No,
Because
what
I'm
is writ petition must be, Lordship, kindly consider what is his prayer and whether these prayers can be.
What is the law? Why?
Lot of prayer ta ki chaicho.
Prayer my lord, yes. What I am praying, my lord, because only sub-dealer is entitled to get the followed trade certificate. Sub-dealer has no right. Sub-dealer additional authority will issue the license of business to work under the dealer. Now the my lord, sub-dealer applied for this trade certificate. This is not permission under the law. Because the agreement will be made with the sub-dealer, agreement in between the manufacturers and the dealer will be executed to supply the vehicle. Whatever agreement will be made in terms and conditions regular. That after getting the trade certificate, the dealer shall engage the my lord sub-dealers for the purpose of marketing of the petitioner, and my lord, in dealing with the unregistered vehicle with the intending my lord buyers, when the my lord deal is confirmed, the my lord such my lord confirmation will be referred to the dealer. But dealer has only power for registration of the vehicle. That is the law. Section 39, section 41.
Against whom he is making this prayer, who are those sub-dealers?
What is the
in favor, who are those sub-dealers? They are not made parties. No specific ever made.
What is my prayer? I don't know. So, my lord,
his prayer is.
What is your prayer?
the my lord application already made by sub-dealer.
Let them make party, let them come also.
No, against because I made the representatives. Can see the my representatives.
Representations in all matters do not help. Page
number 82. Page number 82.
If you have allegations against sub-dealers, they have to come on record.
Irrigation means sub the particular, not sub-dealer. Particular
You
sub-dealer.
are asking for a direction upon the authority not to issue any trade certificate in favor of.
This is my case, nothing else.
But the law doesn't permit. So how can, why are you asking for a separate order?
Already, my lord, issued 2 or 3. I have not challenged because they have been at party.
Because.
But enforced by
So that was your remedy. You should have challenged that. If you are aggrieved by any specific action of the authority, you have to challenge that. You cannot be an advisor to the authority to say that, and by way of a court's order, that please do not issue any trade certificate because it's not permitted by law. If it is not permitted by law, the law authority will not issue. That is the prerogative of the authority. If you are aggrieved by any action,
law says only dealer is entitled to apply for sub-dealer, trade certificate, not sub-dealer.
Mr. Khan, for example,
I got the information, travel force because.
Can you ask for a declaration of, you are asking for a declaration of the law. You are asking for a declaration of the law.
Support the law, they only dealer entitled to get the trade certificate, not sub-dealer.
Is it permissible in law? You have to come up again with specific allegations.
And my lord, kindly.
May I submit one thing? Supplementary affidavit.
What supplementary affidavit?
Supplementary affidavit for what?
Annex those documents.
Then he has to make some amendments, made
Annexing
them
which
parties.
which documents? If you have a specific, yeah, I can allow you to withdraw with liberty to file afresh. That I can do.
Well, can you adjourn the matter? I'm coming next. Can you give me one chance?
You are placing a law
Placing the law.
and you are asking for a direction upon the authority to abide by the law.
Yeah.
This is not permissible.
But they will abide by the law.
They will
act because they will not.
it is not your case that they are not abiding by the law.
The authority mala will issue the trade certificate and accuracy law, nothing else. I am not against that.
This is like calling for a
blanket order.
Mr. Khan, this is like asking for a declaration that murdering a person is illegal.
Already, I've come with a representative.
I
Representation,
grant
anything
such a
and everything.
Representative has come out. I not the blanket representation.
declaration is not, it doesn't help everything.
Well,
You
actually, it
cannot
is
ask for a
admitted fact, Milo.
declaration of law.
Well, it
You
is
have to
admitted
come-
fact.
You have
He
to
admitted,
seek
admitted.
relief in a writ petition. What is the relief sought? No relief. You are asking for a declaration to advise the authority that yes, follow the law, do not go against it.
Yes.
Is that possible? Under the law, yes.
No, law. Because authority,
No.
well, it is admitted
You
fact,
will,
Milo.
if you want to take an adjournment, you
Malo, kindly
can,
adjourn the matter, Malo, I am coming.
but you will only waste another day. Let me
No,
assure
no,
you.
not another day, Malo, I come with the Malo because it is a, Malo, because it
Because
is
supplementary
the case,
evidence
Malo,
will
it is
not
admitted
include
fact, Malo,
this.
they are
He
giving the
admitted.
This
Yeah,
is
what? He admitted.
Have you stated it is admitted fact?
He admitted.
Have you stated that they are issuing trade certificates?
Yes, I have stated so that is already license, issued the license.
Challenge the
State
same.
certificate.
Bring it to
So I
the
have
court.
You
Because,
have to challenge that issuance.
well, I am coming next to Malo, if I satisfy that.
There is a violation
next
of
level.
law, you have to challenge the violation.
আজকে এই প্রবলেম কিছু তো
You
রেডি
cannot
আছে
ask for a declaration of the law.
Declare the law, but by the all the authorities decided to. Malo, kindly. Malo, kindly.
দেখেন অবশ্য মাই লর্ড
Kindly. Well, I admit, because I have prepared my draft, my lord, without any fault, man. Yeah, I assure my lord, I'm coming next. time.
Yes,
Kindly
I'll
adjourn.
grant you an adjournment. Will you come back after vacation?
After, not back, before vacation. Before vacation.
না না
Yes.
আর টাইম নষ্ট করবো না
No urgency. No urgency, Mr.
Well,
Khan.
This is urgency, Malo, already started to issue that.
Other matters are waiting, spending so much time on an issue which is really not.
They are decided.
All this type of petition.
They are already decided. Look, I never, I prayed this.
No, after vacation,
Well,
but this
it
is
was
not
case
so
of I
urgent.
never prayed the
When he has never, my lord, make any amendment that here is the specific case
I
of
also made the apartment.
what amendment?
They have already showed down and so started.
No, 18th October.
18th October.
18 of.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 18th October.
হবে না
Oh, 18th is a, no, 18th is a Wednesday.
wait Wednesday ঠিক আছে
18 of.
19th is last.
and my lord and 19th is the last
Well, before,
কি চাইছো কি চাইছো
19th, 18th I say.
before the 10th or 15th.
আবার সময় নষ্ট
Not urgent at all.
not at all not
Several
at all.
urgent matters have to be dealt with before vacation.
Well.
Next matter.
and my lord
312.
my learned friend has drawn my lord's attention to an enactment, but without my lord reading the proviso. The proviso, that is, my lord, say that subject to payment of fees, my lord, even the sub-dealers be, my lord, allowed, my lord, that is, my lord, the trade
No.
certificate.
Only license of business.
Adjourn date.
State certificate license is not the same thing.
Next
In
matter.
any event,
Writer of
this petition is not
I
maintainable.
cannot explain the law is, but they have not gone through that provisions. License of business and the test is not the same thing.
I'm on the
Don't
next-
mislead the court.
Mr. Khan, I'm on the next.
Like
matter.
this, I'm
Well,
a-
without-
I can explain, I
Without any, কোনো কিছু ছাড়াই বলছো স্টেট এই কথা তো নিয়ে এসো
don't mislead because I'm giving the service
is the
24 years. I can never mislead the court.
I have passed an order, Mr. Khan. Please, this is
Well,
not
it's a mislead the
expected of
court.
you.
Just I come to a.
But I do not know, my lord, when he was in my side, what he has done. I do not know.
Next matter, who is the petitioner?
312.
আবার একদিন নষ্ট করবে কোর্টের পরের দিন
312
আপনি তো fees
petitioner,
পাবেন। দুটো তিনটে fees করবেন। আবার অসুবিধা নেই।
petitioner in 312.
কারণ this is same thing.
Mr. Khan, he's so agitated with the earlier matter, he doesn't know.
Not that matter up to.
This cannot be my lord,
315,
Same.
lawyers, my lord, attitude, this should not be.
315, now 350.
Yes,
312 I am appearing.
same matter,
Oh, yeah.
same issue. Trade certificate, trade certificate,
For filing evidence service.
same order. Rajiv. Affidavit of service আগেরটার মতন same. 15 বললো না? শুধু কোনটাতে affidavit of service আছে দেখে নিয়ে add করুন।
চাপিয়ে দেবেন না অসুবিধা হবে।
একটা কল করুন তাহলে।
Till 315.
Till 315 my lord, I am appearing 312, 13 and 15.
একটা কল করুন না।
15 of the same
আস্তে
order.
আস্তে এনআই খান একটা এমন জায়গায় চলে যাচ্ছ, তোমার রিটায়ারমেন্টের দিন এসে যাচ্ছে।
এইটি তো।
উত্তেজিত করছে তোমার
313.
Same order.
কিছু নিয়ে আসলে তবে অর্ডার দিতে হবে। খারাপ লরিয়ার খারাপ। আর আমার সময়
14.
ট্রান্সপোর্টটাকে বেঁচে দিয়েছিলেন।
315.
উদ্ধার হয়েছে।
Same order.
তলায় কি করতে হয়? উচ্চ
116.
16 I appear. I am for the petitioner.
এটা আমার বিস্তর
আমার বিপরীত।
Yes.
This matter relates to compassionate appointment, my lord. Petitioner is the married daughter of the employee, my lord.
Ramanna.
Died in her son.
Compassionate appointment is
compassionate
this court, this
হ্যাঁ,
court.
This is
না, না।
working in the CSTC, my lord. CSTC.
I'll release it.
Service matter.
Group 6.
Group 6 service matter.
The matter pertains to group 6 of the
এটা তো-
classification
হ্যাঁ।
list. Paragraph, the matter is released due to lack of
কাজ করতো CST.
আমার সময় কি করতাম? আমার সময়
আর না।
317.
একটু রাখ, 16.
317.
My lord, I beg to appear for the petitioner, my lord. My lord, since internet connectivity is not good, my lord, I pray for not today, my lord.
I am appearing for this.
My lord, I am in Delhi Supreme Court, so my lord, the internet connectivity is not good, my lord.
When are you coming back? When are you coming back, Mr. Sinha? Mr. Sinha, when are you coming back?
My lord, day after tomorrow, my lord. My lord, day after tomorrow, my lord.
On prayer of the, very well. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 10th October.
My lord, grateful, my lord.
Next.
Eighteen.
Affidavits exchanged.
Yes, ma'am.
Yes.
Whereas petitioner's application dated 21st February 2017
was allowed in the board meeting of the State Transport Authority on 17th March 2017.
Yes.
Application is 21st February 2017. It was allowed on 17th March 2017. Accordingly, an offer letter was issued, page 49.
17th March, your application for?
My application for grant of permanent stage carriage permit on the route Kolkata to Kesar. On my lord, application date is 21st February 2017. It has been approved, my lord, allowed on 17th March 2017. Well, accordingly, an offer letter was issued, page 49. Offer letter was issued, my lord, on 29th March 2017. And it was extended up to 19th October 2018. Page 49. Offer letter was extended up to 19th October 2018.
Yes.
Extension of offer letter, my lord, by handwritten, my lord, your lordship. Offer letter was extended up to 19th October 2018.
Yes.
Since my vehicle was fitted with sleeper berth, I was not allowed. I have made a prayer, page 51, on 17th October 2017. That kindly allow me. It has not been allowed. Ultimately, your lordship kindly come to page 60. I have 60. I have submitted the
Yes.
documents relating to vehicles. WB76A6717 and WB41E2924. My lord, on 9th October 2018. Page 60, annexure P3. And it has been docketed by 3404. These two vehicles, my lord, along with next page 61, I have been allowed to deposit permit fees to the tune of rupees 48,000, page 61.
Yes.
And it has been deposited on 29th June 2018.
Yes.
Along with all these documents, my lord, I have submitted along with this letter, my lord, the timetable, fare table, page 68, 69. Everything was submitted before the authority on 9th October 2018, before the expiry of that offer letter.
Yes.
Thereafter, my lord, no steps was taken by the authority. So, page 70, they declared vacancy. My lord, page 72, serial number 19. This vacancy was declared on 31st January 2020. Page 70.
This is during pendency of your application.
Pendency, not application. Pendency, the issuance of permit.
Yes, yes.
They declared vacancy again on 31st January 2020, page 70. By serial number, my lord, page 72, serial number 19. Kolkata to Kesar. But meanwhile, my lord, one vehicle, my lord, out of that those two vehicles, one vehicle, my lord, was not roadworthy. That's why petitioner, page 73, petitioner made a prayer that in respect of one vehicle, I may be allowed to place a new vehicle. That is, my lord, page 73. My lord, in lieu of 2924, my lord, I have applied 76A6594. Both are sleeper coach.
6694. Yes.
6694. Now, this has been made on 21st September 2020. My lord, along with the certificate of registration, my lord, page 74, I made a prayer for allowing me to place that vehicle in place of earlier vehicle. Well, these two vehicles, my lord, well, it has been registered as Bharat Stage 3 and registration, my lord, 11th August 2017, page 74. Your lordship kindly noted registration of 6717 is 11th August 2017 at the top right hand.
Prior to page 73, where is the intimation before the authority of change of vehicle?
No intimation.
You have not given any intimation to the authority.
Since the permit was not issued, I made a prayer on 14th September 2020 that instead of that one vehicle, I may be allowed to place another vehicle. And I have made in this letter, my lord, in terms of your offer letter, my said class though complied with all the formalities later in said offer letter by submitting all the relevant requisites, including the documents of the vehicle through the letter being docket number such and such, but said permit has not yet been issued from your end.
Yes, but change of vehicle, that permission?
I made a prayer.
Where is the prayer?
That is page 73.
73, you have not prayed for change of vehicle. You have said that issue permit in respect of these vehicles.
6717 and 2924.
Yes, in lieu of this.
Yes, my lord.
So prior to that, a permission was necessary? Since offer letter was in respect of another vehicle, the earlier vehicle.
Yes, my lord. However, all the enclosed relevant documents, updated documents in respect of the said two ready vehicles, 6717 and 6694 in lieu of WB 41E2924 are hereby again submitted by my said class for forthwith issuance of permit on the interested route.
This in lieu of no permission is necessary.
I made the permission to that effect.
Where is the permission asked for? You have only said that instead of this, I'm placing this.
I am placing this.
Yes.
And my lord, I would like to request you to issue permit forthwith in favor of my client as prayed for in terms of your offer letter.
So even before any permission was granted, you have placed the vehicle.
Yes, my lord.
Yes,
I placed that vehicle. Since my lord, on that date, my lord, no permit was issued.
Offer letter was valid.
Offer letter was valid. And my lord, two vehicles, my lord, all are 11th August 2017 registration. Two vehicles. Now, my lord, your lordship kindly come to the first resolution, my lord, 29th January 2021, page 80. Operative portion, page 81.
Yes.
When Mr. Arif Hossain and Javed Ali found absent on call, and an advocate appeared on behalf of them. Their matter was discussed in details, and finally, members of the STA West Bengal decided to reject the prayer for replacement of vehicle, as well as reject his application for grant of permit, which was allowed by STA in its meeting dated 17 March 2017, because permit with BS3 compliant vehicles is already restricted by the STA resolution dated 27 November 2020, and also on the ground that he has failed to obtain permit since long. However, he has the liberty to apply a phrase for the said interstate route or any other interstate route with BS4 or above compliant vehicles if vacancy exists. A vacancy is also declared arising out of rejection of joint application of Muhammad Arif Hossain and Javed Ali.
Yes.
This is my lord rejection, my lord. My lord, they can reject my prayer for replacement, but they cannot reject my grant of permit. Self-same authority has no power to recall its own order. They may reject my replacement of vehicle, but they cannot reject my application for grant of permit since it has been allowed by the authority long before. Now, my lord, your lordship, kindly come to the, this decision was taken on the basis of the decision taken on 27th November 2020. Your lordship, kindly come to page 84. What is the resolution taken on 27 November 2020?
Page 84, yes.
Page 84. But the Honorable Sri Sumit Saw such and such, my lord, portion, my lord, the Honorable National Green Tribunal, Principal Bench, New Delhi, in the matter of OA number 33, 2014, Subhash Dotto versus the State of West Bengal and others, in their order dated 27 November 2018, observed that the principal reason for the ambient air was identified to be into emission apart from the road dust and some other hazards. The Honorable Bench had further observed that even the Honorable Supreme Court was in season of such matter with regard to the question of serious deleteriousness of auto emission and referred to the directions Honorable Supreme Court by which introduction of Euro 6 standard vehicles was called for from the year 2020. And orders of the tribunal in furtherance of the orders passed by the Honorable Supreme Court for phasing out old vehicles. Keeping in view of the safety and security of the passengers and providing better services to them, as well as keeping in view of the above noted observation of the Honorable National Green Tribunal, Principal Bench, New Delhi, in the matter OA 33, 2014, Subhash Dotto versus State of West Bengal, in their order dated 27th November 2018, members of the STA decided in general not to approve any application for the interstate route permit with vehicles having BS3 emission norms in future. Lordship, kindly note that STA decided in general not to approve any application for the interstate route permit with vehicle having BS3 emission norms in future. This resolution in general was taken on 27 November 2020. Long before that, my application was allowed.
Yes.
On 17th March 2017. Now, my lord, your lordship, kindly come to the page 86.
Yes.
This is the another resolutions passed by the self-same authority after the improved resolution dated 27 November 2020. My lord, decision taken in the meeting at the top, my lord, at the bottom. The decision taken in the meeting. The matter was discussed in details and members of STA decided that only those approved applications of interregional route which are originating, traversing and or terminating with KM area by the STA prior to 27 November 2020 with BS3 vehicle will be allowed to get permit.
Yes.
It may be interregional, my application for interstate, but point is application before 27 November 2020 will be allowed. Next, my lord, A.
Your application is an interregional route.
Interstate.
Interstate.
Maybe, my lord. Where application has already applied with permit fees. I have already deposited permit fees. And other documents required to obtain permit on or before.
This order pertains to interregional routes. So
Maybe,
this is
my
not
lord, but
applicable in your
point
case.
is, my lord, before 27 November 2020.
Yes, the principle. Yes.
Principle is before 27 November 2020. And that decision was taken in general, not in respect of STA, not in respect of the interstate permit, not in respect of the interregional permit. 27 November 2020. That resolution was taken in general.
In general covers everything. Covers
In
all
general
the-
means every permit.
all the- Yes.
And point is before 27 November 2020, whatever application is being made, along with permit fees, that would be allowed and that would be approved. Page 89, my lord. This resolution was taken on 29th January 2021, page 87. My lord, 89, first, second, third, fourth paragraph. Mr. Mustakam Ansari appeared personally. He produced documents for ready vehicle bearing registration number WB37C4139 2011 model.
It's a PS3 vehicle.
2011 model, my lord. That has been allowed. That has been allowed.
When was this allowed?
My lord, page 91. Application first, second, third paragraph. In the middle, application of Muhammad Mustaqim Ansari having ready vehicle WB37C4139 were approved. 2011 model, my lord. At that very point of time, BS4 was not introduced.
The date of this resolution?
Yes, my lord.
The date of the resolution?
Yes, my lord. Page 90.
24th August.
Sorry, my lord. 24th August.
2021.
24th August. 24th August. Now, your lordship, kindly come to the affidavit in opposition. I am skipping the reports. 2 reports were filed, my lord. But thereafter, my lord, since objection, affidavit in opposition, 2 reports go.
So the opposition will be comprehensive. Let us come
Yes,
to the
madam.
opposition.
That should be. After the filing of two reports, my lord, affidavit in opposition has been filed pursuant to your lordship's order. My lord, page 2, paragraph 3. The pivotal issue raised in the said petition is that whether the two.
Give me a minute, please. Didi. Other matters release for the day.
Other matter release, except item number 318 for the day.
And next matter. Next matter, similar matter also.
Yes, affidavit in opposition.
One matter is the combined. One matter is the combined list. Parties are here with us, what file our pleadings.
Combined list. It's not called. I can please do not file like this. Let me file when it is called.
My lord, page 3, my lord. Page 2, paragraph 3 of the opposition, my lord. Affidavit in opposition. And the media.
Page 2, paragraph 3. Yes.
3. I am showing the relevant portion, relevant paragraph only.
Give you a minute.
Reply to our question. তারপরে সুপ্রিম কোর্টের জাজমেন্ট করবে এখানে আছে নাকি দেখ আমাদের রিপ্লাই আছে নাকি দেখ কোনটা দুটো আলাদা
Yes.
Well, the pivotal issue raised in the said petition is that whether the two vehicles of the BS3 pollution norms compliant. which the petitioners were required to place for grant of permanent residence permit way back in 2017, as per the offer letter issued in favor on 19 March 2017 by the competent authority, can be allowed to place the same in the year 2020. When the guidelines for placing any vehicle for grant of permit, I failed to understand, my lord. I submitted in 2017. Next, my lord. My lord, page 3, paragraph B. Offer letter was issued 29 March 2017. There is no problem.
Paragraph?
My lord, page 3, paragraph C. Paragraph C.
See a bare perusal of the.
A bare perusal of the said offer letter dated 29 March 2017 appearing in page 49 would transpire that the petitioner has to issue an acceptance of the offer within 30 days from the date of receipt of the said letter. The petitioner was also required to submit certain documents as requisitioned therein also within 30 days from the date of receipt of the said offer letter. The petitioner, however, failed and neglected to comply with the terms and conditions of the said offer letter by not submitting any of the documents nor any letter of the acceptance within the stipulated time as mentioned in the said offer letter. But it is the affidavit, my lord. This affidavit is being affirmed by Provi Chattopadhyay secretary. Well, without going through their own records, how they can avert this type of statement? May I ask a question to Michelle, my lord? Patently false and untrue.
Yes.
All on a sudden, on or about 7th August 2017, the petitioner through his letter 31st July 2017 made a prayer before the answering dependent for issuance of the offer letter. Thereafter, my lord, when I filed documents that has not been whispered in the affidavit in opposition, that has not been whispered at all. And one of my affirmance in my writ petition clearly speaks about the submission of all the documents in terms of the offer letter, much before the expiry of the offer letter. According to Rule 141 of the West Bengal Motor Vehicles Rules, an offer letter is valid for a period of 6 months. Initially, it was issued for 30 days. Thereafter, it was renewed. Now, my lord, question whether PS3 would be allowed or not. My lord, paragraph G, Mehta, Supreme Court's order.
D.
Paragraph G for goal. Page 4.
Yes.
My learned senior friend referred the Honorable Supreme Court's order, which has been referred in the impugned decision dated 27th November 2020. I am coming, I have annexed the order. This order, my lord, your lordship, now thereafter, my lord, nothing has been mentioned in the offer in the affidavit in opposition regarding the legitimate claim of the petitioner to.
This is for sale and registration.
Yes, my lord. Yes, my lord. Now, your lordship, kindly come to my reply. I have annexed all this order. Your lordship, kindly come to my reply.
Yes.
Page 18. This order has been referred. 24th October 2018, in opposition, as well as in the impugned order, impugned resolution dated 27th November 2020. Now, your lordship, kindly come to this order has been passed on 24th October by the Honorable Supreme Court in MC Mehta case. My lord, operative portion, page 19. Honorable Mr. Justice Deepak Gupta pronounced the reportable judgment of the bench comprising Honorable Mr. Justice Madan B. Lokur and Honorable Mr. Justice S. Abdul Nazir and His Lordship. The court made the following observations in terms of the signed reportable judgment. Therefore, in exercise of the power vested in this court under Article 142 of the Constitution, we read down sub-rule 21 of Rule 115 and direct that sub-rule 21 of Rule 115 shall be interpreted and understood to read that no motor vehicle conforming to the emission standard Bharat Stage 4 shall be sold or registered in the entire country with effect from 1st April 2020. So there is no whisper about the grant of permit in respect of BS3 vehicle or
Existing
BS3 vehicle is restricted by the order of the Honorable Supreme Court. Nowhere, my. Though in the impugned resolutions it has been averred that the BS3 has been restricted. Now your lordship kindly come to the Subhash Datta case, page 21.
Yes.
It has also been referred, my lord, in the impugned decision, in general decision. Huh? Your lordship kindly come to again, my lord, resolution, my lord, 27th November. Page 84
Of the writ petition.
of the writ petition. Everything is being done in the case of the petitioner following the decision. Page 84. 27 November 2020. Right? Here, my lord, M. Mehta case referred. MC Mehta case has been referred in the opposition, but in resolution only Subhash Datta case has been referred, and Supreme Court orders was referred, but no reference. Page 84.
Yes. Yes.
না গো সুপ্রিম কোর্টের অর্ডারটা কোনো রেফারেন্স নেই, কোনো রেফারেন্স নেই, সাইটেশন নাই. However, in the opposition, it has been referred. Citation has been referred, MC Mehta case. And your lordship has seen the order. Now, your lordship can Subhash Datta case.
Yes.
Subhash Datta case, 27 November 2018. In the input resolution, 27 November 18, order was referred. My lord, I am skipping over the entire year. My lord, page 24.
Yes.
This is regarding pollution only. Page 24, paragraph 12. We accordingly direct the state of West Bengal to pay a sum of ₹5 crores as interim environmental compensation, which shall be deposited to the Central Pollution Control Board. The amount shall be deposited within a period of 2 weeks from hence, failing which it shall entail further compensation with 1 crore per month. This is being imposed following the polluter pays principle in terms of the section 20 of the National Green Tribunal Act, and also the laws include the absence. Now, nothing has been transpired. My lord, your lordship, page 24. MC Mehta case has been referred. My lord, paragraph 10, your lordship, paragraph 10, 23. MC Mehta case has been referred. Unfortunately, in spite of more than 7 months having elapsed after the order dated 24th April 2018, that is the MC Mehta's case order, no tangible action taken by the state has been placed before us. The State Pollution Control Board has remained blissfully silent in spite of the fact that it is the primary responsibility of the board as a regulatory authority to ensure that the ambient air quality, this particular word has been mentioned in the input resolution. The ambient air quality is maintained within the permissible limit. In the meanwhile, it is an undeniable fact that the ambient air quality has deteriorated. In MC Mehta versus Union of India has been held that decline in quality of environmental reflects failure of the authorities to perform their obligations under the constitutions and the mandate of laws. If the regulatory authorities enter connive or act negligently by not taking prompt action to prevent, avoid or control damage to environment, natural resources, people's health and property, the principle of accountability for restoration and compensation have to be applied. We may refer to MC Mehta versus Union in this regard. Apart from this, the Honorable Supreme Court has also laid down that the accountability cannot be restricted to the polluter alone, but also upon the governmental agencies who are responsible for enforcement of the laws to prevent pollution. That is the ambit of the order that despite the MC Mehta's case order, government agencies are manufacturing BS3 vehicles, BS4 vehicles after the cut-off period, after the cut-off date. That is the 27th April 2020.
Yes.
So these two order, my lord, in my humble submission, has no nexus with the impugned resolution dated 27 November 2020. Simultaneously, in case my decision also, in case the resolution in my case also, because my lord, that resolution has been referred in my resolution. Now, your lordship kindly. Page 26 of my reply.
Yes.
This is the notification dated January 15, 2019 of the Transport Department, Government of West Bengal. Very important notification, my lord, this is. My lord, first, second, third, fourth, fifth, that after now, therefore, after careful consideration of the entire matter with a view to phase out 15-year-old commercial transport vehicles from plying within twin cities of Kolkata and Howrah, and to streamline the use of vehicles in general, the governor is hereby pleased to issue the following directions as contained herein under. Commercial or transport vehicles, my vehicle is transport vehicle. Commercial vehicles or transport vehicles which are 15-year-old from the date of initial registration, registered anywhere in the country, are hereby not allowed to enter the areas covered under the Police Commissionerate of Kolkata, Howrah, Bidhannagar, and Barakpur, which include the twin cities of Kolkata and Howrah. This shall apply to all commercial or transport vehicles, including trucks, trailers, buses, taxis, etc. Principle of the order in
15 years.
Principle of the order in the MC Mehta case as well as the Green Tribunal bench is restricted, is limited only to not allowing any transport vehicle or commercial vehicle beyond 15 years old. That is only the principle of those two orders which has been referred in the input resolution. From the date of registration. Now, my lord, the paragraph 2. The 15-year-old commercial or transport vehicles registered within Kolkata Metropolitan, if found flying in violation of this department's order, 2012, this another order was passed, shall be seized. But this 15 years restriction order was originally passed on 13th August 2020, 12. Shall be seized forthwith by the law enforcing authorities. The concerned regional transport officer or additional regional transport officer, as the case may be, shall realize all unpaid tax, other dues, initiate procuring under section 192. That is the different matter. Now, the notification of the 31st December 2018, page 27. Same thing. This is the notification, my lord, or this is the gazette notification.
15 years.
Same. This is the gazette notification, page 26. Our original notification is, my lord, page 27. This has been gazetted, my lord, in 2019.
Yes.
Notification is 31st December 2018. Now, my lord, a clarification was sought for by the Transport Department, STA. My lord, page 30, on 25th February 2019. Well, with reference to an directed information order number 28 April 2030 was issued by the Transport Department as comprehensive guidelines governing different transactions related to registration of vehicles, grant of permit and change of address under different jurisdiction of the state. And the same was issued as an order, not notification. By notification dated 7th August 2012, the Transport Department clearly prescribed the applicability of BS norms for registration of a vehicle as well as issuance of permit for the same in the state. The order in question has no overriding effect on the notification. However, it is further clarified that the words new vehicle used in the clause C of para 2 under item A of the order should be interpreted not as a newly registered vehicle, but as a vehicle which is to be placed apace against a permit, in accordance with the prevailing restriction on BS norms in terms of notification dated 7th August 2012. This notification was prevailing at the time of submitting my vehicles in 2018, my lord. This notification was prevailing. So my vehicle comes under the definition of a new vehicle, which is being placed for issuance of permit, not for the registration of the vehicle. Thereafter, this notification, my lord, another notification was issued by page 31. This notification was issued by the Transport Department Gazette notification. Your lordship kindly noted this is the Gazette. These all are the Gazette notification. My lord, September 12, 2013. My lord, new permit at the left side, my lord.
Notification in April 13 and published in September.
September 12, 2013. Well, new permit for new vehicles registers. Well, left column.
Yes.
And my second matter. Vehicle registered in the areas other than Kolkata Municipal Corporation area and the areas under Salt Lake and Lecter Police Station. But my route covers under this second one. Bharat Stage 3 norms.
Yes.
Now, my lord, page 33. In 2013, my lord, on 26th April, my lord, another order come guidelines for registration and permit has been issued. In this case, my lord, at the bottom, restriction on BS norms, paragraph C. In case of paragraph B, in the areas outside the Kolkata, as mentioned above, no new vehicle other than BS4 or BS3 compliant vehicles can be registered. In case of stage carriage permit, in case of interstate route, my route is interstate route. C. In case of interstate, the new vehicle to be placed in permit must be minimum BS3 norms compliant.
Yes.
I am also covered by this notification also. August 2012, my lord, what order has been referred, but your lordship kindly come to page 36. Page 36. My lord, an order was passed by the Honorable High Court, Calcutta, on 18th July 2008 in WP number 6377W2007, restricting plying of 15 years old commercial vehicle. So origin of the 15 years old, restriction of the 15 years old comes from this order, my lord. 15 years old commercial vehicles like bus, minibus, meter taxi, and two-stroke double mode 3-vehicle passenger carrier auto rickshaw within Kolkata included order passed by the Honorable High Court on this order. After careful consideration, of the entire matter and for compliance of the order of the Honorable High Court order, it has been decided that no commercial vehicle within Kolkata metropolitan area, which is 15 years old, shall be allowed to ply in Kolkata metropolitan area. Accordingly, renewal of stage carriage permit failing which shall be allowed only up to 15 years of age. This is the first order issued by the Transport Department, Government of West Bengal, in the light of the order passed by this Honorable High Court at Calcutta on 18/7/2008, which went up to Supreme Court. I am coming on that, my lord. This is the notification 7th August 2012. Herein also, my lord, same thing is being done. Page 38. Page 38. Rest of the area in the state of West Bengal, excepting the city of Kolkata, as mentioned at one above, Bharat Stage 3 emission norms. Page 38.
Yes.
I am skipping now, is my lord, this is not necessary. Now, your lordship, kindly come. Following this notification and circular regarding BS3 norms of the Government of West Bengal, page 43, division bench of this Honorable Court has passed an order. Page 43. This is the order passed by the Honorable Division Bench. I am showing the relevant portion, my lord. Page 43. The sole question which arises for consideration before this court centers around the definition of a new vehicle, which has been read out by in the earlier. The sole new vehicle presented for grant of a permit under the Motor Vehicles Act. That is the clarification sought for. And the related question as to whether such new vehicle is one which is purchased from the manufacturer and is BS3 norms compliant, or is a vehicle which must be BS3 norms compliant and should not be attached with any other permit at the time of making an application for a particular permit. This is the sole issue in that appeal. Well, at page 46. Therefore, the third paragraph. Therefore, this court, for the convenience of maintenance public transportation in the area which stands still denied or regular access, disposes of this appeal by permitting the STA to take an appropriate decision, considering the applications of all the parties, including the present appellant and the private respondents, based on the terms of the notification dated 7th August 2012. Well, the Honorable Division Bench has also relied the order dated, the notification dated 7th August 2012. As clarified by the order dated 25th February 2019, what your lordship has seen, that clarification of the Transport Department defining a new vehicle to be BS3 norms compliant, and such vehicle being otherwise eligible for applying of a permit without the requirement of being registered as a vehicle purchased straightway from the manufacturer. The court further finds no inconsistency between the order dated 25th and notification of 7th August 2012, as clarified by the order dated 25th February 2019. The common requirement being presentation of a vehicle for a permit, which is BS3 norms compliant. But this order was passed by the division bench, my lord. Accordingly, my lord, pursuant to this order, my lord, next page 49, this STA, my lord, took a decision allowing the BS3 norms permit in, my lord, 20th September 2022. My lord, at the top, bottom, my lord, page 51.
Yes.
Members of the STA observed that the decisions in the instant matter has already been taken in STA meeting 26th February 2019 in terms of clarification on 25th February 2019 of Transport Department. Thus, in compliance of order of Honorable High Court Calcutta dated 1st March 2022, members of the STA decided that decision of STA meeting dated 26th February 2019 would stand, whereby the BS3 was allowed. Next page, 26th February 2019. it has been stand.
52.
Operating portion 53. That is a new vehicle. And my lord, decision, my lord, page 54. Will remain in operation. Now, your lordship kindly come to the page 55. The Honorable Supreme Court's order, last order, my lord, page 55.
Yes.
Operative portion, my lord, this order was passed in Uttam Kumar Bhakat, and my lord, order was passed on 14th July 2022. Next page 56. No, my lord, your lordship kindly come to the first, yes, 55.
55.
55. My lord, it is relevant, my lord. We have heard Mr. Piyush Kumar Rai, learned counsel appearing for the petitioners. By the impugned order, as such, the High Court has directed the STA to take an appropriate decision considering the application of all. But against that order, my lord, passed by the Honorable Division Bench of this Honorable Court, the State Transport Authority, the one of the party preferred SLP, that SLP has been dismissed. That SLP has been dismissed. Now, my lord, page 57. So far, 15 years old vehicle and BS3 vehicle is concerned, my lord. The Honorable Supreme Court on 6th December 2022. Order.
Yes.
57.
Yes.
Learned senior counsel for the appellant submits that the only grievance in respect of the impugned order is qua the direction to the state government to ensure that public transport vehicles below BS4 are phased out in 6 months, so that after 6 months, only BS6 vehicles would ply in the state of West Bengal, including in the cities of the Kolkata and Howrah. This appeal was preferred by the state of West Bengal, my lord. Transport Department. If it is her say that in terms of the direction of this court in order dated 24th October 2018, no motor vehicles conforming to the emission standard Bharat Stage 2 was to be sold or registered in the entire country with effect from 1st April 2020. Not the ply of vehicle has been restricted. Thus, registration was carried out till that date as permitted, and therefore the 15-year period has to be counted from the date of registration. Otherwise, it will amount to making the vehicles unusable in a period less than 15 years. That is the last observation of the Honorable Supreme Court.
This is still pending.
Yes, my lord. This order, this appeal was prepared against the NGT order. Against that fine. My lord, now your lordship kindly come to the affidavit in opposition, whereby 2 subsequent notification during pendency of this writ petition was issued by the Transport Department.
Yes.
One is, my lord, 1st March 2023. That is page 12 of the affidavit in opposition.
Yes.
Self same, my lord, self same. More or less same, my lord. 2nd June, page 16. Since, my lord, 1st March 2023 order has been modified by the order dated 2nd June 2023, I am, my lord, here, my lord, in case of new stage carriage permit, clause A, subclause 2, small letter A. I will also find it, but I am placing, my lord, page 16.
Page 13.
Page 16.
Yes.
Same, my lord, same. Page 16, my lord. 2nd June. This is the last notification.
Yes.
And by this notification, my lord, all the other previous notification has been superseded. Paragraph 2, my lord.
Yes.
To review the related procedure and issue fresh guidelines in supersession of all previous notifications. So 1st March notification goes. Now, my lord, clause 2. In case of new stage carriage permit, restriction on emission standard of Bharat Stage PS norms. No new permit shall be issued by any authority having its originating terminating point at CBD, Kolkata, Bandstand, Kolkata, Howrah station. This is not in my related. My lord, clause 2. In case of interstate routes, the state authority will encourage placement, will encourage. This is not the restriction, my lord, will encourage. Placement of BS4 emission norms compliant vehicle preferable. The state transport authorities of all the reciprocating states may be informed and requested by the state authority of West Bengal to issue their permits accordingly. So here, my lord, no restriction. I say, my lord, in my humble submission, I will tell you, lordship, that there is no restriction in BS3 by this notification. My lord, if clause 5, my lord, if the route is exclusively outside Kolkata, my route lies in exclusively outside Kolkata.
Yes.
The vehicle to be placed in case of new permit. Vehicle to be placed. This is the my lord, against my lord existing permit, my lord. This is not in my case. Replacement. This is in case of replacement. No, the vehicle to be placed in case of new permit may preferably be minimum BS4 norms compliant, except the cases mentioned below in para C. Para C. That is the goods carriage permit. So by this clause, my lord, clause 5, page 17. This is the first time restriction has been imposed upon the petitioner to place his BS3 vehicle. This is the first time this restriction has been imposed, which is patently illegal in the eye of law, in view of the Honorable Supreme Court's order, as well as the order passed by the Honorable Division Bench of this Honorable Court. And the earlier order notification regarding BS3 norms has not been considered in this order, my lord. That was the gazetted notification. That was not considered in this order, my lord. Nowhere, my lord, 2012, 2013 order has been, or the Honorable Supreme Court's order, which has been dismissed in the Supreme Court, which has been confirmed by the Honorable Supreme Court, my lord. That has not also been taken into consideration in this impugned order.
Yes.
So my humble submission before your lordship, and my lord, page 19, only, you're also kindly go to page 19.
Yes.
B, permit issuance, renewal and replacement. Clause A, no new permits are to be issued to transport vehicles registered in any region in compliance of the above guidelines, subject to compliance of the related provisions of the MP Act and rules made thereunder. Restriction on use of vehicles in any region based on pollution norms as specified in this guideline or otherwise should be clearly endorsed on the permit positively. But there is no specific renewal of any existing permit is to be allowed subject to complete restriction on the use of the vehicle with age more than 15. Only this restriction only with age more than 15 years as imposed in this order. As imposed in this order. Wherein, my lord, no imposition to that effect. And other conditions such replacement is to be made within the specified period as imposed by the existing provisions of the Act and rules made thereunder. So, my lord, in my humble submission, that the vehicle placed by the petitioners in terms of the offer letter having a emission compliant norms of BS3, my lord, should be allowed by the authority. And since my lord, permit fees has also been deposited long before, my lord, and these unreasonable restriction, my lord, this is the unreasonable restriction has been imposed in the subsequent order, my lord, which has been issued during pendency of the writ petition, not before the writ petition. And my lord, my lord, the order passed by the Honorable Green Tribunal as well as the Honorable Supreme Court, as disclosed, as taken into consideration in the impugned decision dated 27 November 2020, my lord, has no nexus with regard to BS3 restriction of the BS3 norms vehicles, my lord, in respect of any permit. And fourthly, my lord, my permit is outside Kolkata. So, my lord, BS3, these particularly this, in respect of the new permit, they can. But I have placed the vehicle long before the restriction. So kindly consider this aspect, my lord. That's all, my lord.
Second matter also the same?
Same. Only route is different.
Only route is different.
Only route is different and
Continue, sir. Mr. Debra, very specific questions to be answered. Primarily, the notification gives prospective effect, not retrospective effect. The BS3, BS4. So please consider these issues and come back. And the judgment relates to 15 years old vehicles.
That is another. Those who are operating their vehicle, that is newcomer channel. Is the newcomer. Is the newcomer main problem is that. Is the newcomer and he default in placing his vehicle within the stipulated channel.
no.
That is not permissible under the law.
It was placed. Page 60 of the writ petition says it was placed.
My specific allegation, the vehicle, construction of vehicle is totally changed. That is why I rejected his
Construction of vehicle.
construction of vehicle is sleeper coach. That cannot be permitted.
The earlier was also sleeper coach.
No.
Come.
No such rejection order was passed. No such rejection.
After lapse of consideration.
In 2018, no such rejection order.
Both which are sleeper coach in the respect of the safe duty state and in place of the detailed with seats, as has been applied by the petitioner. He applied for seated. Such deviation from the original proposal will not be allowed by the council. In absence of any express approval of the STA for them, there no lordship kindly see no lordship pointed out approve. If you approve, only write a letter without approval. Change the nature and character of it. That cannot be. Hence the petition for granting permit was rejected. In spite of knowledge of the same, the petitioner sat tight over the matter without taking the state for the execution of such. There is a
Now, your lordship kindly note hard in part, your lordship.
I ignore.
deliver the judgment by
Your lordship is going to deliver the judgment. Your lordship hard.
Without hearing the state at all, going to
No, no.
give the judgment. I have not heard the state.
order says
318, 19, same order.
Yes.
order says
Well, your lordship,
Same order.
well, your lordship kindly hard in part. Your lordship
But in part, very difficult for me.
order says
hard at length.
That doesn't make any difference. Heard at length is not heard in part.
no, partly. Lordship